Welcome to the University of Dayton School of Law. I wish I were physically welcoming you at Keller Hall, but I am genuinely excited about the opportunity to reach out virtually to so many people and to talk about such an important topic. Today, we're going to be looking at several issues related to education and equity. And frankly, in this time, I think that's a particularly important topic. We are living in a very polarized time right now. And I think that the more that we can learn about ways to reach out to all members of our school communities, the better off we're going to be. We have a wealth of fabulous speakers today. We have William Throw, we have Bill Fisher, we have Jillian Bradshaw, and one of the most noted scholars on law and education, I think probably the most noted scholar on law and education that we could imagine, and that is Charlie Russo. And Charlie is both director of the PhD program in educational researchship and a research professor at the School of Law, and we are so happy to have him. I'm going to turn things over to Charlie now so that he can get things going with the program. But again, welcome. I do know that some folks are thinking about CLE credit. We're still awaiting the final approval from the Ohio Bar, but we hope to have that shortly. We will be in contact with you as soon as that comes through. And for folks who are out of state, oftentimes your local bar will allow you to get CLE credit from something that the university puts on. So if you'll contact us, specifically Leanne Ross, we will get you a certificate of attendance so that you can walk through that process. But again, welcome. And Charlie?
Good morning, Dean Shaw. Thank you very much for the very kind introduction. I'm happy to have everybody here. I'm hoping everybody can see my screen now. If not, if somebody would let me know. Before I get started, let me just also make a few little notes of thank you. I'd like to thank Dean Shaw and of course Dean Andy Strauss, who's not with us today, for their ongoing support, not just for this opportunity to speak with you on school law, but for so many things we do together in the School of Law. It's a great team of people to work with. Beyond that, as you may well be aware, a number of people are behind the scenes, as it were, and I would like to thank them for all the things that they've done. I don't want to leave anybody out. Leanne Ross in the Dean's office, Colleen Leary in our alumni office, Paula Sedaris in advancement, I think it is, Mackenzie Marin, who's helped with the technology, and of course, Jordan Burgess in the Dean's office, who's also been very, very helpful in dealing with the slides and that sort of thing. And of course, I'd like to thank our speakers. Dean Shaw has already introduced them, so you know who they are. Bill Throw and Bill Fisher will be coming up after I'm done. Then Dean Shaw will speak, and Jillian Bradshaw will be speaking, and then we'll end with a panel with all of us at the end of the day. So again, I welcome you. This is our third annual School Law Conference, and we are planning one for next year. We don't have a theme yet. We've been theming it to key issues from the Supreme Court. Let's see what comes up. They've granted cert in a couple of cases, but there are still some interesting issues floating around out there. So stay tuned or be in touch with us or one of the ladies such as Colleen or Paula. They could give you an idea of where we'll be. We will try to get on that soon. Dean Shaw and I will work on that before too long. Again, thank you for coming in on a Friday morning when you have lots of other things to do. Let me do an apologia first. I don't know about yourselves, but when I go to presentations, I really dislike having somebody read slides at them or at me. That being said, this presentation this morning is wordier than most of the presentations that I put together. I think now Jordan has put the third version of it. I cut out about 15 slides between last night and this morning to try to shorten it up. And the beginning of it, I'm probably going to go through more quickly then later on, if I get to the points of discussion are more important. I will be done in a little over an hour at 10:15, then we'll take a break for 15 minutes. And I'm told the way we'll deal with this are questions when the speaker is done. In a live session, I'm happy to have questions in the middle, but I understand our dynamics are just a little bit different. And so we'll have to do it that way. So please forgive me if I appear to be reading some at you. I'm going to try to paraphrase everything. As I say, I don't like having people read slides at me. Also, before we came on the air, I was talking with Ms. Leanne Ross, who's been facilitating an awful lot, and as well with Colleen, who's been helping with the CLE. Most of my comments come from a paper that Bill Throw and I have forthcoming in the University of Dayton Law Review. So if you'd like a copy of the full paper, admittedly before going through student editing, so there might be a typo or two, if you contact them, or I think they'll just send them out to you automatically. And if you have any questions for me, if you could see my email at the bottom, it's very simply crusso1@udayton.edu, CRUSSO, the number 1, at udayton.edu. One other thing I did not do this time, Bill Throw and I talk about this from time to time because we work together a good bit. I usually put some cartoons in, but I think this is the first presentation I've done without any cartoons to kind of break it up just a little bit. That being said, as you can see on the screen, my topic, and then Bill's going to do a related topic, is on Espinoza versus Montana Department of Taxation, which was truly a triumph for religious freedom and school choice. My next slide is simply the outline. And again, I don't want to read things at you, but you can see where we're going. I was debating with myself, even this morning, of skipping Roman numeral 2, but I think it's worth going through very briefly the history of the Supreme Court on aid, and I'll go through from Everson up to Agostini and some of the later cases, if that means anything to you. Just a little bit on tuition tax credit. There's a pretty good number, probably about 25 or 30 lower court decisions, but they don't really add a whole lot except to say that tuition tax credits have been in the law. Then a bit of a case crunch on Espinoza versus Montana, and 2 important reflections, at least 2 that Bill and I worked on together to give you something to think about. As I try to tell my classes, as you listen with me this morning and as we listen with everybody today, my goal is to ask people to think with me, not necessarily to think like me. I'm not here to convince you that one decision is better than the other. These are simply personal reflections and beliefs that Bill, my good friend Bill, and I have worked on, and we were fortunate enough to be able to reduce it to a manuscript and share it with other people. But if you disagree, that's great. If you agree, that's great too. We're just here to kind of lay out the issues for you and hope that you'll have a productive day with us. Dean Shaw, in her introduction, mentioned we're kind of at odds with each other within the nation. And so whether you love him or hate him, my opening quote comes from Donald Trump on June 16th. And I do think for those particularly involved in education, it's probably difficult to disagree with him. I mean, it's easy enough to disagree with him on lots of things. But again, you could read it. School choice is the civil rights statement of the year, of the decade, and probably beyond, because all children have access to quality education. As many of you know, those who've met me, I grew up in a small town that some of you might not have heard of called Brooklyn, New York. And in my native New York, the public schools, as in many big cities, have had all kinds of issues. And I am not suggesting that school choice is a panacea. It is not going to be a cure-all. But when one thinks about it, if you live in a place like New York City, where many of the public schools are failing for a lot of reasons, and not blaming the teachers, there are many, many combinations. But I wonder if it's not worth giving parents a little bit of choice in terms of sending one of their children, something rather, to the schools they'd like to go. Because towards the end of my presentation, and I know some of you from the School of Education who are listening in are familiar with people like Coleman and Greeley, who talked about social capital, that 1 + 1 can equal 3, so to speak, in a school where parents choose to send their kids and become involved. So school choice, I think, is in fact a major issue, regardless of the person who made that point. And most of us who have commented on it, recognize that Espinoza is in fact advancing school choice for all people. Again, a simple statement that you may already know, just if you've heard of Espinoza in the news. And we use words like stunning victory because it is, in a sense. It's a pretty much a complete turnaround to where the Supreme Court would have been 20 or 25 years ago. And I say as not unexpected, Erwin Chemerinsky, who some of you may recognize the name, is a dean out in California. I can't recall his school, but even he had predicted this outcome about a year ago. I write a monthly column for one organization, and in my predictive column, I cited him for that proposition. And I also say that based on some of the material we'll talk about a little bit later. But just as a reminder, it is significant because it allowed states, or it allowed parents, to receive benefits that might not have been otherwise generally available to them from state programs. There's a case I'm going to mention a little bit later, Trinity Lutheran versus Comer from a few years ago. The court kind of broke that dam, if you will, and flooded the field, so to speak, with parental rights and the rights of those who are religious. It said that in that case, a state could not deny generally available benefits to a faith-based organization or believers simply because they are religious. And Espinoza advances that cause. So a brief outline for the next maybe 5 or 10 minutes on the Supreme Court cases involving aid to students. For those who may have studied school law or even basic con law, some of this will probably be familiar with you, but I think it's good to put it up as a background, even though the court did not play too much off of it in its decision in Espinoza. A little bit of a general introduction, obviously, which I'm doing now. The child benefit test, then Lemon v. Kurtzman, and Trinity Lutheran versus Comer. And I will talk about that case in a little bit of length because the Supreme Court did, given its significance in Espinoza. Again, a bit of an apologia. I do my best to control my speaking patterns, and even though I've not lived in New York for a quarter of a century, I probably still speak a little more rapidly, but I'm trying to slow down so that I hope you can follow what I'm saying. Everson versus Board of Education, as you may remember, from 1947, is considered, and I think it's fair to say, the beginning of the Supreme Court's modern jurisprudence. It was the first case under the First Amendment involving religion and public education, or something involving religion with public education. And it came from the state of New Jersey, dealing with transportation for kids to and from their faith-based schools in the state of New Jersey. One of the important things that came out of Everson, and there's more detail on this in the paper if you'd like, is that in Everson, Chief Justice Black introduced the metaphor of the wall of separation between church and state. And certainly with regard to prayer, which is not our topic for today, it's pretty much been the perspective of the Supreme Court for the past 3/4 of a century. And on aid, it was really until about 1997 with Agostini. If you're interested in some more detail, there's a little bit in the article. I cut back on it because we were long on our length. But I believe, and I've had some conversations with friends, good friends who don't entirely agree. If you know Justice Black's history, as a young man, he had been a member of the Ku Klux Klan. And as Justice Alito's opinion discusses in Espinoza, the so-called Blaine amendments, which denied aid to schools, were greatly supported, openly so, by the Ku Klux Klan. And so my belief, at the risk of sounding paranoid, was that I think that Justice Black planted the wall of separation metaphor as a kind of Trojan horse, because in this case, he upheld the aid for the non-public schools or the kids in the non-public schools, but in most of the later cases, it denied aid to kids who came or attended non-public schools. And that might be an interesting debate for another time in another place, but the wall of separation metaphor has played a large role in the Supreme Court's jurisprudence since that time. During that time, excuse me, I think it's fair to say that the Supreme Court jurisprudence with regard to aid, not religion, I'm just going to speak of aid, went through three fairly distinct periods. And as most of you as students of the law and attorneys and or law students recognize, that periods don't abut necessarily cleanly. There'll be a gap. But the state's jurisprudence, the Supreme Court rather, jurisprudence began in 1947 with Everson, and it continued until 1968 with a case from New York, Board of Education versus Allen, which I'll describe in a few moments. And during that time, the Supreme Court enunciated the so-called child benefit test. The child benefit test is a legal construct. It's kind of like Santa Claus and the Easter Bunny. It allows aid, state aid, to go to children rather than the schools they attend. I think it's kind of a fair analogy to compare it to a third-party beneficiary. Parents are paying tuition to the non-public school, which delivers education to the child, who's that third party. And in the same way, the state provides aid to the school, which then funnels it to the child. And so the child is the one who benefits from it rather than the institution. Typically, it involved transportation and books, later learning materials, not direct money, not direct payments. And I think it's been a very useful construct. For the better part of the last 15 or 20 years, I have been on a panel at the Education Law Association. In recent years, my good friend Bill Throw and Julian Guerrero, former student of mine and good friend as well, do a panel on religion. And we have 4 or 5 very different perspectives, from pretty close to accommodationist to pretty far out separationist. And I think one of the things we talk about is being able to disagree, but be disagreeable on these issues, which get people pretty excited. And these are, of course, points on which reasonable people can and will disagree. The second period began in 1971 with the famous Lemon v. Kurtzman case, and it ended in 1985 with Aguilar v. Felton, the case from New York City, where the Supreme Court denied aid just on the fear of entanglement, one of the 3 parts of the Lemon test that I'll talk with you about a little bit. During that period, if it was not a book or not a bus, as I like to say in class, the aid was impermissible. The court denied such things as laboratory equipment, magazines, maps for classrooms. And I can understand some of the things, such as computers or overheads, they would not give. But if you're a science teacher, I don't know how one teaches a chemistry lab without the test tubes or the Bunsen burners. But in any event, during that period, aid was limited significantly. The tide began to turn in 1972 with the case from Arizona, Zobrist versus Catalina Foothill School District. It involved a student who was blind who sought to attend a Roman Catholic high school. In the process, he requested a speech and language, sign language interpreter. The local due process hearing denied the student's request. Federal District Court in Arizona denied the student's request. The Ninth Circuit upheld the denial of the student's request, but the Supreme Court reversed in favor of the student about 3 weeks after he had already graduated. But in 1997, the court pretty much eviscerated, not the court, pardon me, 1998, the Department of Education eviscerated Zobrist by placing limits on the amount of aid under special ed. But in 1997, another case from New York, Agostini v. Felton, the court essentially overruled Aguilar and allowed the on-site delivery of benefit to kids who attended faith-based schools in New York City. Not surprisingly, if you know much about New York City and or non-public education, Roman Catholic schools were something like 87% of the total of schools. And the second largest were Hebrew day schools at 7%. So the pretty good mix of non-public schools and kids who were served. But in any event, that period ushered us into where we are pretty much today. Again, 1947, Everson allowed the state to reimburse parents for the cost of transporting their kids to school. When I was in high school, I lived on one side of Brooklyn, took the subway every day an hour to get to school, and we were given what was called a bus pass or a subway pass. It was about the size of a baseball card, and we would just wave it at the person in the token booth, and we could just enter onto the subway for free. Every month it was a different color, and certainly if they saw a 30-year-old or an adult using one of the cards, they were supposed to stop them. In any event, transportation was then okay. In 1968, Board of Ed versus Allen, the state of New York enacted a statute that allowed the state, or allowed itself through local school boards, to provide children in faith-based schools with textbooks used for secular instruction. They could not use religious texts. You could not get a Bible, for example, and they might even be able to get a book not on the same list as the public schools, as long as the books were approved at the state level. And the court said that was okay. And even during the 1970s, cases upheld transportation in that form and loans of textbooks. If you took a course on con law, you had to have run into the Lemon Test. Lemon Test may have met its demise in Espinoza, but again, a quick overview on it. Lemon, as you may recall, had a companion case, early DV Crescenzo. Lemon was from Pennsylvania. It involved a statute purchasing secular services. Rhode Island was the early VT Crescenzo case. It involved salary supplements for teachers in non-public schools. Demographically, at that time, Rhode Island was the most Catholic state in the country, so there was an inclination to provide greater forms of aid to Roman Catholic schools. Pennsylvania was fairly Catholic, not nearly to that level, but in the northeast part of the United States, the National Conference of Catholic Bishops has a pretty good sway in political circles. There were still enough Roman Catholic politicians who would do what they could to help the bishops. In Lemon, as you probably know, and I'll go through this kind of quickly, the Supreme Court said that anytime law and religion come together, or education and religion come together, there must be a three-part test to get through. Must have a secular legislative purpose. There must be a principal or primary, not no effect, but a principal or primary effect, neither advancing nor inhibiting religion. And number three, the kind of catch-22, it cannot create an excessive entanglement with religion. Very briefly, secular legislative purpose. If you think, for example, about the IDEA, Individuals with Disabilities Education Act, or Title I, they provide aid to children on discrete bases. Kids must have a disability under IDEA. Title I or Chapter 1, kids must come from underprivileged families and have additional educational needs. The court has agreed those are secular purposes. I don't like to mince words too much, but the second part says a principal or primary effect, not no effect. Allowing textbook loans, allowing transportation to and from school is some form of aid, but I think most would agree it's not principal or primary. The catch-22 happens with excessive entanglement. It's hard to know what excessive entanglement was. In fact, it was almost whatever the Supreme Court decided it was. But as a bit of an aid, in Lemon, the court said there are three additional tests to take into consideration, and you can see them on the screen in front of you: the character and purpose of the institution, the nature of the aid, and the resulting relationship. For those of you who attended or attend UD, when you're at the law school, if you look out on the side, you can see Holy Angels Church and Holy Angels School. Holy Angels School and any faith-based schools, such as the Dayton Christian Academy or the Hebrew Academies, have a goal, a primary goal of inculcating the faith of those schools in the children who attend them. That's not what a university is about. So this government's been more willing to allow aid to faith-based schools. UD, as many of you may know, rivals the Ohio State University in governmental aid because of the wonderful work that's done over at the University of Dayton Research Institute. And they fill out the same forms as Ohio State or UC or Bowling Green or any state institution. The second idea is the nature of the aid. In school settings, indirect aid such as textbooks or reading materials are okay. Very unlikely the money would go over as it does, for example, to UD in light of the work with the US Air Force. And then what the relationship is, again, bringing up excessive entanglement. Nobody's kind of sure what it is, as you see on the screen. And as I mentioned, it is a catch-22. Most statutes, most programs get past the first two parts of it, but they fail based on excessive entanglement. And in 1985, in Aguilar v. Felton, the issue was whether New York City and other places, but it came out of New York City, could provide Title I services on site in faith-based schools throughout the 5 boroughs. The New York City Board of Ed put together a really good comprehensive list of kind of do's and don't do's for teachers coming in. They worked in rooms that had all of the religious materials removed from them. They were told not to discuss religion. They were told that they still work for the city. They don't report, so to speak, to the officials in the faith-based schools. When it went to the Supreme Court, it passed the purpose test, it passed the effect test, the first two parts of the test, but it failed excessive entanglement. Justice William Brennan, some of you may recall, was the Catholic vote for so many years, and Brennan very often took positions that disagreed with what the Roman Catholic hierarchy or Roman Catholics would have wanted in an attempt at transparency. And he, in a 6-3 decision that he authored for the court, invalidated the program, not on the basis of excessive entanglement, but based on the fear of excessive entanglement, even absent any allegations that anybody had violated those provisions. So it was kind of a low point, and that, as those of you who are old enough may remember, that's when the portable vans and portable units would be erected outside of the faith-based schools in the driveway or in a playground or something of that sort. And the difficulty came about, I was going to skip over this, but purpose and effect came from prayer cases, and excessive entanglement came from a case on tax walls. In 1997, that all changed. Agostini was essentially Aguilar on appeal. In a decision written by Justice O'Connor, who had dissented in a very strong dissent, the Supreme Court did not reverse itself. It dissolved the injunction that held Aguilar in effect, but in reality, it essentially overruled it. And it said that because there were sufficient safeguards in place that the services could be provided on site. She raised some questions because it said it did not violate any of the standards the court had used absent governmental indoctrination. They did not make any distinctions on religion in terms of who received the aid. She also pointed out that there was no excessive entanglement, despite the court's earlier ruling. In something that's really more of a footnote to the decision, I would say, the Supreme Court modified the limit test, reviewing purpose and effect only and making entanglement part of effect. But in practice, the courts have always stayed with the 3-part test. So beginning in 1997, the Supreme Court had a much more relaxed attitude towards aid. And 20 years later, 3 years ago, in Trinity Lutheran versus Comer, there was a case from Missouri where a faith-based preschool applied to the state of Missouri's program that dealt with scrap tire program, they called it, Department of Natural Resources. They offered the program a small number of grants basically designed to cut down on landfill. They were providing money that people or schools could purchase chopped up old tires in landfill that become safe surfaces in playgrounds for children. As you can see, it made reimbursements to qualifying institutions to purchase these materials, to put them under the swings and the other playground equipment available to children. Quoting from the case, the center serves students of any sex, race, color, religion, nationality, and ethnicity. Even though it was operated by the Lutheran Church, it welcomed anybody. It also allowed the playground to open to children in the neighborhood after school hours, so it was, in a real sense, a community resource. And they applied for the grant to make the playground safer. The school came in 5th out of 44 applicants, but was denied the ability to participate because there was language in the state constitution modeled after the so-called Blaine Amendment, which forbade aid to sectarian institutions. And I put sectarian in quotes because that's the word in there. And just as we have certain code words today for a variety of different things, sectarian was the code word for Roman Catholic. And it was, in fact, an example of egregious anti-Roman Catholic prejudice that made its way into about 38 state constitutions. And you can read the language of the Constitution that prohibits aid to any church, sect, or creed of religion, or any form of religious faith or worship. Federal trial court granted the state's motion to dismiss the lawsuit. It relied on Locke v. Davie, the case some of you may recognize from 2004, involving a student out in Washington State who had a scholarship to study at a state university, but he wanted to study to become a minister, and that was excluded by the program, and the Supreme Court upheld that exclusion. A divided Eighth Amendment agreed that the court did not violate either the Free Exercise Clause or did not violate the Free Exercise Clause because it did not have to ignore the Blaine language. A partial dissent, something that happens in Espinoza, tried to distinguish Locke and Trinity Lutheran on their facts. They refused a hearing en banc. The Supreme Court took the decision, and in a 7-2 order written by Chief Justice Roberts, sorry for the Rehnquist, reversed in favor of Trinity Lutheran. You can read on your own. I'm not going to bother you with the names of who concurred and dissented. But interestingly, Roberts wrote the opinion in Trinity Lutheran, and he again wrote the decision in Espinoza this past term. After reciting the facts, he went back and took a look at the Establishment Clause in relation to the Missouri Constitution. He said it did not prevent the aid. He also took a look at the Free Exercise Clause and how it applied, and ultimately came to the conclusion that aid was permissible. He found that the policy that prevented aid discriminated against religion simply because it was religion, and perhaps it's a mixed metaphor, but he said that's not kosher. He then offered 3 reasons why the lower courts made a mistake in relying on Locke v. Davie. He said in Locke v. Davie, he was denied the scholarship because he wanted to study religion. Here they were denied simply because it was a church. It was not promoting anything. It was not studying anything. They were denied because of who they were, who they are, if you will. The second, in Locke, the student wanted to engage in religious ministry. Here, they just wanted to make the playground safe. That's pretty secular activity, regardless of whether you agree with the outcome or not. And third, he said Locke sought to include religion by letting faith-based institutions and programs participate as long as they did not study pastoral theology. Um, he said, conversely, and again, I apologize for reading, there's no dispute that Trinity Lutheran was put to the choice between being a church and receiving governmental benefit. The rule is simple, no churches need apply. I tried to do a little bit of homework on that, but I can't help but to think that makes me think of the sign, of which I've seen pictures from the 1850s and 60s in Boston, no Irish need apply. And I kind of wonder if he was playing off of that. Maybe I'm reading too much into it, but I think it would apply. And then in, if you will, the one great quote from the decision for Justice Roberts ending it, he said, the exclusion of Trinity Lutheran from a public benefit which it's otherwise qualified solely because it's a church is odious. That, if you will, it stinks to high heaven. So he reversed and remanded in favor of Trinity Lutheran. The dissents, of course, disagreed, but in the interest of time and getting to other material, I will skip ahead and tell you a little bit about tuition tax credits. As with so many of the issues we're dealing with under generally and under litigation, tuition tax credits are somewhat divisive. The issue had reached the Supreme Court earlier in Arizona Christian School versus Wynn. However, they never reached the merits of the claim in that decision. It talked about whether the parties challenging it had standing because they failed to demonstrate an injury, so they did not address the merits of it. Generally speaking, and I think both sides would agree with this description, they allow parents and others, such as businesses or corporations, to allocate or donate funds on a tax-free basis to private nonprofit organizations that then manage those funds and disperse those dollars to parents and the schools they wish their children to attend to. On the one side, supporters think they're a boon. They think they're a real good thing. They see it as a form of school choice, which it is certainly, and they see it as providing parents with the opportunity to have a greater say in the education of their children in terms of where they will be educated. On the other hand, critics of the tax credits tend to see it as removing aid from faith-based schools and violating the Establishment Clause. Bill Throw is also well-versed in school finance, something I'm not. He can probably give you more detail on the studies which show that these programs have a minimal impact on funding because they really do not reduce the amount that goes to the public schools. If anything, they almost reduce aid to the faith-based schools. But again, there are two pretty clear-cut sides in that issue. If you read the full article, it'll put you to sleep with about 15 or 20 pages of a review of the litigation. Suffice it to say that the litigation falls into two categories with mixed results. Proponents win some, they lose some. Opponents win some, they lose some. And there are about half of the cases bring up religious claims that it's violating the Establishment Clause. Other ones do it on the basis of non-religious claims, saying it's violating various funding statutes and school finance statutes in the states where these programs have been enacted. I think that will begin to slow down as we move to the post-Mendoza world. In my discussion of Mendoza, which I'd like to keep fairly quick, give you a little bit of the factual background and the discussion of the program itself, a bit of analysis of Roberts' majority opinion, and then just a slide on the concurrences and dissents, because they do raise some interesting points in both of those areas. Again, the tax program, as earlier when I described tax credits, is to provide school choice, allowing these donations to be used to that purpose. Under the program, schools can become a so-called qualified educational provider, and they were under that, they are entitled to dollar-for-dollar tax credits of up to $150 a year for donations to SSOs, school servicing organizations, who fund the money through to the schools. Even in a state like Montana, and I say even in a state like Montana, which is sparsely populated, $150 per year is not an earth-shattering amount of money. In order to become one of these schools, and I tried to compress it a bit to put it on one slide, it had to be a non-public school with accreditation from the state, not a homeschool, had to administer nationally recognized standardized assessment tests, meets all the health and safety requirements, and it qualifies as an exemption from compulsory attendance. Some of you may remember, and I chose not to put it in there for space and time, but 1925, Pierce versus Society of Sisters, kind of the Magna Carta of non-public schools in America. It allowed those schools to operate as exceptions to the compulsory attendance statutes. On its face, it did not exclude religion or religious schools. And once the program started, of the 13 schools that participated in the program, 12 were in fact faith-based. I've talked about this a little bit, so I'm going to be quick here. Basically, when parents make those donations to the organization, they funnel the money to the schools. And then there are some limits on how much money the schools can receive and spend down at the bottom that were really not much of an issue in the case. The state legislature, when it enacted this law in 2016, granted the Montana Department of Tax Revenue the authority to implement and administer the statute in conjunction with or consistent with the 1990-72 no aid clause in the state constitution. There was a more recent state constitutional convention in 1972 that modified their original constitution, and its prohibition is stronger than the aid in the First Amendment. It's stronger than the establishment and free exercise clauses in terms of denying aid. It adopted a Blaine type amendment, one of, and I say, of 38 states, because in a dissenting opinion back in Trinity Lutheran, Justice Sotomayor's dissent identifies 38 states. Some people will say 39 or 40. It's not material to discussion except to say that a vast majority have this kind of language in their cases, in their constitutions. That issue was in fact discussed back in Trinity Lutheran, but the court ignored it, as they largely did here head on. This case began when Kendra Espinoza, the lead plaintiff for 3 mothers in northwestern Montana, challenged the state department's rule that the faith-based school their children attended could not participate because it was faith-based. A trial court in Montana, state trial court, granted her motion for summary judgment in a non-published opinion. It did not even take that rule into consideration, said that the statute was okay. The Supreme Court of Montana reversed in favor of the state, as you can see. First, it acknowledged that its constitution could in fact be more stringent than the First Amendment, and that it did in fact prevent any form of aid, and there are those buzzwords against sectarian schools. Second, it thought that people in the State Department of Education exceeded their authority and said they didn't have the right to do what it did, even though it struck the rule down. The 3 moms appealed to the Supreme Court, which in a 5-4 decision ruled in favor of the mothers and school choice. After the facts, Roberts briefly acknowledged that the program did not violate the Establishment Clause. And that's important because he basically sidestepped Lemon, and in a footnote in Justice Thomas' discussion, which unfortunately I did not include in the slide, Thomas basically said the Lemon test is dead, and seems that it might be at this point, but as Justice Scalia once described the Lemon test as a ghoul rising from the dead to terrorize little children and school lawyers in Senator Rich's Long Island, we'll know that the Lemon test is dead the next time a case gets to the Supreme Court, maybe. Roberts went on and delivered the opinion. There's the breakdown of the members of the court, which is not entirely relevant at this moment. He described the question as whether the free exercise clause precluded Montana Supreme Court from applying that aid provision, no aid provision, to bar aid to religious schools. He accepted or conceded that under the Montana law, it violated the Montana Constitution, but that still made it necessary to address the question under free exercise. He then went back and, as I promised, cited Trinity Lutheran here, which applies under the 14th Amendment. If you go back to Cantwell and that sort of thing down at the bottom, it protects religious observers against unequal treatment, and it cannot impose special disabilities simply on the basis of religious status. He went on to review his own opinion from Trinity Lutheran, pointing out that it provided important precedent that a state or a program could not single out believers or faith-based institutions from otherwise generally available aids simply because they were religious. He then criticized the court, and again, citing Trinity Lutheran, as the Montana court did not. I like to quote, "The free exercise clause protects against even indirect coercion. And the state punishes the free exercise clause of religion by disqualifying the religious from government aid, as Montana did here, saying that this is subject to strict scrutiny, something that he talks about later on in his opinion." He then rejected the Montana Department's reliance on Locke v. Davie, again, the case from Washington involving a student who wished to study to become a minister. He said that here, in Locke, the student wanted to be a minister, but here the program did not identify any particular religious course of study. It simply said you could not, or they could not attend religious schools because they were religious. It puts parents between the proverbial rock and a hard place that they either take advantage of the benefit or not send their kids to the religious schools of their choice, and the Constitution forbids that. He added that another distinction was that Washington state had a historic and substantial state interest against the funding of the training of clergy. And that tradition simply was not present either in Montana or in this case. For those of you who attended law school, my apologies for a 30-second con law review. You remember that the court applies 3 tests in various issues. At the low end, if the court applies rational relations, and there's a rational relationship to a legitimate governmental purpose, the government tends to win. There's a middle test that it applies very rarely. And then there's the high end, the strict scrutiny. When there's strict scrutiny, any governmental restriction on the fundamental right, such as freedom of religion, must be drawn as narrowly as possibly and must have a fundamental, must affect that fundamental interest in a minimal way. First, he reiterated again that the program was subject to strict scrutiny, and he rejected Montana's argument that they could in fact separate church and state, to quote him or them, more fiercely than others. He said, this does not qualify as a compelling interest in the face of infringing religion. He then went on to say, this did not, despite what the state and the department argued, advance public education by denying funds from being diverted to private schools. He said, beside that, it only applied to religious schools. And he said, Montana's interest in public education cannot justify an OA provision that requires only religious private schools to bear its aid. It did not apply to non-sectarian schools out in Montana. Another pithy statement, a state need not subsidize private education. But once it does so, it cannot disqualify some private schools simply because they are religious. He began the last part of his decision by criticizing the court's opinion, the Montana Department of Commerce or of Finance decision, that since the Supreme Court of Montana eliminated the tax credit program, they weren't being denied anything because the program didn't exist. He described two arguments in that, and those are the dissent who argued the same. He said, first, it was the judiciary, not the legislature, that invalidated or shut the program down. So he really couldn't say that the program ended. And second, he said that the Supreme Court of Montana should not have even reviewed the case because its decision on no aid violated the federal supremacy clause, which would have barred its jurisdiction. He thus reversed and remanded with the traditional language for further proceedings not inconsistent with this opinion. Justice Thomas, not surprisingly for those of you who follow the court, concurred, but he wrote separately to talk more about the interplay between the free exercise and the free establishment clauses, something I decided not to go into in the short time I have this morning. Justice Alito, I will come back to, gave a fairly detailed history of the Blaine Amendment, after which Montana's provision was modeled. He also gave some additional background on Montana's actual statute that was in play. Justice Gorsuch criticized the Montana court for ignoring the will of the people. The people of the state of Montana elected the legislature, and he was of the opinion that the court did, if you will, an end run around by invalidating a program that parents apparently wanted to keep. He also criticized the court for disregarding the free exercise issue. Not entirely surprising, again, to court watchers, Justice Ginsburg also had an opinion in which she dissented. She partly raised that argument that they did not discriminate against religion because the program closed down, and once the program closed down, no one had the right to do that. She also argued that the Supreme Court majority was in error, that the Montana court did not violate the free exercise clause. I just noticed a typo. Free should have been capitalized in that last line. Justice Breyer's dissent, the longest of the three, was really concerned that allowing this kind of program might result in excessive entanglement. He thought it created too cozy of a relationship between faith-based schools in the state that would not be beneficial in the increasingly religious, pluralistic nation the United States is becoming. Justice Sotomayor joined in Justice Ginsburg's argument that because the program no longer existed, there was no case, if you will. But at the end of her statement, she made at the end of her dissent, rather, last paragraph, she made a statement that I find perplexing, saying that it's perverse. It's, of course, Supreme Court's ruling today is perverse, setting aside well-established judicial constraints, even though she completely ignored the holding in Trinity Lutheran, another case in which she dissented, which forbade the kind of discrimination at issue here. I hope that made some sense to you. And so I'm going to spend the last of my time, and I hope to have a little bit of time for some questions, or else we'll have it later, talking about what this case might mean. Again, a bit of a repetition. It stands for the proposition that religious institutions and or persons cannot be denied benefits or aid simply because of who they are. And I think in a very real sense, it says that religious institutions and people of faith are no longer second-class citizens in the United States. In the paper Bill and I wrote, and I've expanded a little bit here, we had a little more than 2 items. We had 3, but I only have time for 2, are most relevant. First question is whether this is in fact the end of Blaine amendments, and then what this means for school choice. We could certainly disagree, at least those who agree with the court, over whether Espinoza was the final stake through the heart of the Lemon test that we'd like to be rid of. But Robert did write that the no-aid provisions in the 19th century hardly evince a tradition that should inform our understanding of the free exercise clause. If the Blaine amendments are still alive, if they're viable, questionable at best or dubious, they're on life support because they did in fact say it's not permissible or it's impermissible to discriminate against institutions or believers simply for being religion. And it goes beyond eliminating what was in fact legalized bigotry and the Blaine amendments. It provides parents with that freedom to choose where their children will attend school with a little bit of money. Many parents do not have the resources to pay for a faith-based or non-public school. And if you read the newspapers, you've probably seen some of the statistics. At least 500 Roman Catholic schools in America will probably shut down because of the pandemic. I have to believe that will affect other faith-based schools as well. And in Espinoza, the court basically rejected that wall of separation metaphor that Thomas Jefferson popularized. Coming back to the Blaine Amendment and Justice Alito, he explained what some of you may know, that the Blaine Amendment was in fact introduced by James Blaine of Maine. He was a former congressman, senator, and unsuccessful Republican presidential candidate. In his language, or in the amendment, it denied aid to schools under the control of any religious sect. Again, code word for Roman Catholic. A little bit more history. Blaine's amendment was introduced after Ulysses Grant's final State of the Union address in 1875, in which he called for a constitutional amendment forbidding the teaching of religion and prohibiting aid to any school or religious sect or denomination. You can read the language there with me. He added that no sectarian tenet shall ever be taught in any school supported in whole or in part by the state. Congress, more properly the Senate, failed to provide enough votes to ratify the amendment in 1876, but at least 38 states put similar language in their state constitutions. Again, Justice Alito pointing out the history of all of those Blaine amendments, and this is quoting, it was prompted by virulent prejudice against immigrants, particularly Catholic immigrants. I apologize there for the repetition of two words. For those of you who attended or know anything about Catholic education, if you're old enough as I am, you may remember the Baltimore Catechism, a series of memorized questions and answers. And it's called the Baltimore Catechism because it flew out of the Baltimore councils in the 1880s, which mandated at that time that all Catholic parishes open and operate Catholic schools, quote, in perpetuity to educate Catholic school children in their parishes. And the bishops did that because of the tremendous amount of anti-Catholic prejudice in many places. They did not open to be separationists from the mainstream, but they opened because they were excluded. And regardless of whether one likes faith-based education, I think one would have to go a long way to make an argument that they have not done a very fine job educating the children who've attended those schools for many generations now. Back to Alito, he reiterated that it would have barred any aid, and then he quoted a report from the United States Commission on Civil Rights that a prominent supporter of this was the Ku Klux Klan. Ku Klux Klan didn't like too many people, particularly those who thought. So when you think about the fact that they hated the Catholics along with people of Jewish faith and people of color, then I'd say the Roman Catholic Church was in pretty good company, known by who the other people who didn't like them. Again, Espinoza is crucial because it extends protection for religious freedom and religious pluralism that the Supreme Court enunciated in Trinity Lutheran. In Mitchell v. Helms, a case I did not discuss from Louisiana, a plurality that allowed the on-site delivery of educational materials to kids in faith-based schools, Justice Thomas wrote that this doctrine, the Blaine Amendments, born of bigotry, should now be buried. And I think it's fair to say that it pretty much is buried. We'll need some later cases to see. With that, I turn to school choice. And as I've said a few times, Espinoza is certainly a victory for supporters of religious freedom, but very often that religious freedom, at least in an educational context, is tied into matters of attending faith-based schools. Quoting Brown v. Board of Ed as a background, education is perhaps the most important function of state and local governments. And then again, whether you like Trump or dislike Trump, I think it's a fair statement that school choice is the civil rights statement of the year, and probably beyond, because providing all children, depending on where they grow up and how much money their parents have or do not have, is truly a civil rights issue for our times. I think most of us will recognize, oftentimes for issues much larger than themselves, public schools have not been able to operate as well as they should. And lest anybody question it, I'm a strong supporter of public education. I have no interest to dismantle public education, but there are places where it has not been very effective. And I believe that in those locations, parents ought to have the options of giving their kids the opportunity to attend a school that gives them a greater chance for success. Again, school choice is important right now for a lot of reasons, one of which is that when you compare how well American kids do with their international peers, American kids don't do so well. But on top of that, to borrow something from Pierce versus Society of Sisters, 1925, the child is not the mere creature of the state. My apologies for the politically outdated language with the male term, but this was 1925. Those who nurture him and direct his destiny have the right, coupled with a high duty, to recognize and prepare him for additional obligations. That parents should have the right, in this case, allowed non-public schools to exist. By the way, if you're interested, here's a footnote, a recent article from the New York Times talking about how poorly American kids do on many of the international tests when compared with the European or Asian peers. There's a lot out there. I think there are ways we can distinguish those tests, but certainly I don't think anybody's going to make an argument that our kids have entirely been keeping up, particularly in areas such as science and math, areas involving STEM concentration, something in which I am a total zero. The thing that has struck me is that in America, we're big on choice. Choice in a lot of ways. Then why not choice, even if it involves religion or education? And I'm not singling people out when I talk about the teacher unions. I think teacher unions have a role to play in a lot of places. But if you do any research into the background on these issues, you will find that teachers unions are among the most vocal in opposition to any form of school choice. And in the full article, we've got more background that will document that language. I just co-wrote an article with my new dean, Dean Ali Karch-Chelman, in the School of Education about virtual education. And we make the point that I found 2 news articles, although I know there are others. The teacher unions in New York City and Detroit, and I know they were threatening in Los Angeles, have threatened to go on strike if the schools open because they disagree with what's going on. We respect their right to look out for the welfare of their members, but the point in relation to what I'm talking about here is teacher unions have a pretty good say in what happens in schools, and this is one area where they were very much opposed. It is then, I think, and others would agree, essential to grant parents greater opportunities to give their kids the ability to attend the schools of their choice, presumably because they share the values of those schools. Now, earlier in my career, I taught Roman Catholic high school. And I know, in fact, that some parents sent the kids to the Catholic schools simply because they didn't want the kids in public schools. But most of the parents sent their kids to the faith-based schools, as my wife and I did, because we shared the values of those schools and we wanted those inculcated in our kids' lives in a more active way. Many people, of whom I'm one, agree with the notion that school choice offers a possible path to narrowing the achievement gap between the rich and the poor. And the poor are disproportionately minority children of color in inner cities, and oftentimes their white peers. You know as well as I do, having gone through as much schooling as you have in the audience, not every child thrives, not all of us thrive in the same kind of learning environment. And in a very top-down hierarchical model in many public schools, some kids don't do as well there and might benefit from the approach of a faith-based school or a charter school or some other option. And again, I am not here as the apostle. I'm kind of agnostic on charter schools. I am more a proponent of faith-based schools being a product of them. But I think these are things to think about. I think many people would argue that the current educational policies have in fact harmed African American or Black children in particular. And again, while teachers unions, and I'm not trying to be political when I say liberal progressive groups, but many of the think tanks in Washington, D.C., who would describe themselves in this way, were open to choice in many other ways, oppose school choice. And I find it interesting to find that in a recent poll, 83% of African American and Latino parents were in favor of school choice. And again, there's the citation. It's from January 21st of this year, giving that statistic. I think it's important for all of us, even if we choose not to exercise it, need to be aware of the potential benefits of school choice, particularly for kids from minority groups that tend to be less well economically, giving parents a greater say in the schools that their children will attend, because I do believe that this is crucial to their success. As things go, school choice is important because research bears out, social sciences research bears out, that when parents are free to choose where their kids go, they typically become more involved in the schools their kids attend. When our kids attended Roman Catholic elementary schools, my wife had more time to do so than I did. I did some other things, but we were expected to volunteer for some services to help out in the cafeteria, help out on other events, and it becomes people more and more involved. In addition, those faith-based schools typically have some more stringent academic standards. And I know it's very easy for critics to say, well, of course you're going to have higher academic standards. You can dismiss all the kids who are troublemakers. But I can tell you from experience, if the faith-based schools where I taught, two different ones, expelled all the troublemakers, we might not have any kids left at the end of the year. We work with them. I alluded earlier, and this could be a whole separate talk, Coleman and Greeley, beginning in the 1960s, identified this notion of social capital, beginning with studies in Chicago. They studied faith-based schools compared to public schools. I was in high school in 1965, and I can tell you, having graduated elementary school 2 years earlier, I never remembered studying World War II in a textbook or having a textbook that talked about it. We had older books, older facilities, but those nuns, God love them, did a real good job of educating us and building what Coleman and Greeley call social capital, that 1 + 1 = 3, when parents really are more involved as partners with what goes on in the schools because they want their children to succeed. A little bit off the topic, I'd like to tell the little story when I'm in class. I was always very quiet as a kid. People who know me are amazed by that. My brother, God rest him, was much more rambunctious, and it was not uncommon the nun would slap him for misbehaving. And when we'd come home and he would tell my mother, she'd automatically slap him again. Her thinking was, if you did enough for the nun to slap you, that's good enough for me. You must have misbehaved. So she added one to him. I kept trying to tell him, don't tell her. A little bit of joke there, but there was a closer working relationship between parents and the schools. You might be interested in Kendra Espinosa's statement the day the court ruled. She ruled that the court ruled in their favor. She indicates my family can continue to receive assistance. And for many other families across America, there's the opportunity to give their kids choice. What a wonderful victory. In sum, Espinoza did three things. Number one, it recognized that there's no place for religious bigotry of any kind that might have been present many years ago. Second, something I didn't talk about much, but you could read in the full article, Thomas and Gorsuch expanded a little bit on the fact that religious freedom should not be subservient to any other constitutional values. And third, and from a policy perspective, Espinoza removed unnecessary roadblocks to school choice. It now means that states will have the opportunity, should they wish, to develop similar programs. And trying to round out, Espinoza offers, I think, truly a golden opportunity to parents who did not have these opportunities earlier. When I went to Roman Catholic elementary school, graduating in 1963, tuition was $1 a month. My parents had a hard time paying the $350 tuition at my high school. Today, I think they run between $12,000 and $15,000, not just Roman Catholic. But I think it affords parents, not governmental bureaucrats, opportunities to exercise their rights for their kids. President George Bush, another guy who may not be a favorite, but he said, one of the things we need to do is to overcome the soft bigotry of low expectation. If we could put kids in public schools that aren't working, there's not much expectation that they'll succeed. But I think if we put kids in schools where they're going to hold their feet to the fire a little bit, I think kids will stand up and meet the challenge and do real well. Finally, I think Espinoza represents a significant step towards achieving the promise of Brown. Brown and our whole Constitution is based on the notion that regardless of race, creed, ethnicity, gender, socioeconomic, or immigration status, or disability, or anything that I missed, all kids should have the right to equal educational opportunities to go out and succeed and becoming whatever they want. And I think that this is a goal worth pursuing, maybe even now more than ever before in our country, given some of the divides in our nation. I'd like to hope that education will help to perhaps heal some of the wounds, bring people a little bit closer together in the hope for a better tomorrow for all of us. I thank you for listening. I think we have a few minutes for questions, and I hope you will enjoy the rest of the day. We've got some really fine presentations and discussions lined up for you. So I thank you for listening and participating. And now I'll turn it back, I think, to Colleen or Leanne if there's any questions. Otherwise, then we'll go on a break for about 15 minutes. Thank you for listening.
Thank you, Professor Russo. I'll take from here. Again, as he mentioned, if you have any questions, be sure there's a Q&A feature there at the bottom of your screen. Just type in the questions there, and I'll try to relay them to Professor Russo. And as he mentioned, it is about 10:15, which is a time that we kind of put in for a break. So if you want to take a break, you can, and then we'll be back at 10:30. But in between here, you can also stay on and ask Professor Russo questions that you might have. Again, just relay those to me through the Q&A section there. And Professor Russo, we did have one question to start, sure. Which somebody wanted to know, what was this? Obviously, you've talked about this in a lot of respects as far as Catholic schools or Christian schools. What does it mean, Islamic schools? Would this apply as well, even schools that some might feel were extreme?
My apologies for not mentioning the Islamic schools. There's so few of them statistically, but of course it would and it should apply to any Islamic schools, any faith-based school.
Okay.
So and my problem, not with you, not even the person, when we talk about extreme views, I'm not quite sure what that means. You know, some of the things that the Roman Catholic Church teaches have been criticized as hate speech. I would say it's wholly firm. I think those decisions would have to be reached on case-by-case basis. So I think all schools would have the opportunity to participate. Again, my deepest apologies. I not long ago wrote a chapter on on Christian schools, so my mind was locked into just the Christian schools, including Catholic. But certainly any denomination, any faith would be included in that, as they well should be. As to the extremist, I think I need perhaps to know a little bit more on what the extremist position is. And I think that would have to play out on an individual basis. I'm not sure there's a one size fits all for some of those, because again, I've been in dialogues, I've been in debates, I've been at conferences. People would say that some of the teachings of the Roman Catholic Church are extremist on a number of issues, and I would beg to differ. So thank you for the question and for the correction on my part.
And again, if you have any questions as we kind of in this break period here, again, just type them into the Q&A box and we can ask Professor Russo. Another thing, where you mentioned the case and kind of things changing, where is the line now on what states can do in respect to religious schools as far as funding? Is there a line at all? I mean, where could you see this kind of going now? What could be the next kind of case or kind of that could create a flashpoint?
There is, in fact, a case coming out of New England. I think it might be Maine or Vermont. And I've written it up in another one of my articles on this issue, where the state had excluded faith-based schools from a voucher program. And the trial court judge again, I forget the state, decided, or in his opinion said, look, I'm not going to do a rehearing, but this case is going to probably go to the First Circuit, probably to the Supreme Court. So it allowed this particular program to exist. But I think for the extent of things like voucher programs and that sort of thing, litigation will continue. I think it's the beginning of litigation, not the end of litigation.
All right.
I do have a question here. I don't know if you have it.
Yeah.
Somebody asked if I agree with the compulsory attendance requirement.
Yes.
Do you have it?
Yes. Yeah.
Do you want to read it then?
Yeah. What are your thoughts on that? I mean, do you agree with the requirement of compulsory education? And then there's kind of a follow-up. Sure. Should faith-based schools be required to retain students who have unique challenges that might stress the resources of the teaching staff at those schools?
Thanks again for a good question. Yes, without a doubt, I believe in the compulsory attendance requirement. And Pierce versus Society of Sisters, again, 1925, represented the ability of parents, or the right of parents, to send their kids to faith-based schools and have that recognized as an exception to faith-based, to compulsory attendance in public school. 30-second background on that. The state of Oregon, for a long, long time, apparently, and I spoke in Oregon a number of years ago to a group, the Oregon Federation of Independent Schools. The state had almost a public policy of opposition to faith-based and non-public schools. And I was out to talk about some issues for them. And Pierce arose when one of the legislatures, a voter initiative, forbade allowing parents to use faith-based schools as an exception to compulsory attendance because they didn't believe religious schools should exist. And the Supreme Court ultimately, as I've said, and as most of you probably knew, allowed them to continue. That's a right to parental freedom to choose how and where they'll educate their kids. So yes, without a doubt, I believe in compulsory attendance, and I think it should apply to others. The second part, should faith-based schools be able to retain kids with exceptional or unique challenges that might stress their resources? I don't think we have enough time to go into it all, but under the way the Establishment Clause has been interpreted, and it may change now, and based on the regulations in the Individuals with Disabilities Education Act, the question becomes whether whether faith-based schools can or should be able to provide services. Because the faith-based schools cannot receive any funding under the IDEA, they are not statutorily obligated to retain those kids. And as the question appropriately asked, it would drain their resources. I think that if Catholic schools were to receive the proportionate amount of aid to serve those kids, and I've done a lot of work with Catholic schools over the years, in addition to having our kids attend there, I think most of them would be more than willing to include kids with disabilities. Chaminade Julienne, the Catholic high school on the edge of downtown, which is affiliated with UD, has a special program for children with intellectual disabilities. It's been a couple of years since our two children graduated, Shaman and Julian, but they both had classmates who suffered from severe intellectual disabilities. And they were able to stay until they were 21 in an extended program. Shaman Julian has been written up nationally for the outstanding work that it did with kids with disabilities. And the Catholic bishops about 15 or 20 years ago, I just don't remember, wrote a pastoral letter on the need to serve the disabled. So would they serve? Absolutely. But right now they're not entitled to funding and so not obligated. And in a book that I wrote with a good friend that Dr. Bill Thoreau knows, Alan Osborne, we write on special ed. We wrote a book for non-public schools, and he's a public school guy, and he said that as a public school educator, it broke his heart that they could not provide more aid to kids in the faith-based schools, but his primary obligation was to those kids, but he wished that there would have been some way to provide funding to kids in the non-public schools under our system. One last quick comment so others might get in. I have a very close friend in Belgium who has 7 children, and all of his kids attended Roman Catholic schools. But their system of taxation is very different than ours. The money is earmarked for public or faith-based schools. I'm not promoting that kind of a change in the United States. Similar things happen in Australia and New Zealand, other places I frequent. I'm not suggesting we do that, but I think if funding could be provided, there's no doubt in my mind that leaders in Roman Catholic and probably other faith-based schools would welcome these kids as part of their mission. Good question.
All right.
Thank you.
Again, if you have any questions for Professor Russo, just submit them using that Q&A function there at the bottom of the screen. Also, you can enjoy a few more minutes of the break. Again, we'll reconvene at 10:30, but Professor Russo is answering questions in the meantime.
And we will have a panel later on this afternoon, too.
Right, where people could ask questions as well if they want to follow up on any of this. Anything from this decision that would impact, religion related to public schools at all, or any kind of hints or anything? Obviously this didn't deal with that per se, but in the justices' opinions.
I don't see it. They tend to, as you know, and as I'm sure most of the audience, so they try to rule on a very narrow issue. So in terms of religious practices or prayer or things of that nature, I don't see any impact in there. There would be some aid. Will it have an impact on financing public education? I defer to my friend Bill, but the studies that I've seen say that any financial impact is pretty negligible. Because while they're losing a little bit of money, they're not serving the kids that money is following. So I don't see it having a significant impact on public education. That being said, I would defer to anybody with greater insight on the statistical and financial matters. I don't claim to be a financial person, but I don't see much in the way of that happening.
All right. Okay, well, I don't know that we have any other questions right now, so I guess we can give you a break, Professor Russo, for a few minutes if you want. And again, for everybody, we will be back at 10:30 to continue on with Mr. William Thoreau's presentation, which Professor Russo, you'll be introducing.
I'll introduce him, right. So should I mute?
Yeah, I think everybody can. Yeah, if you want to take a break as well, I think.
I'm happy to sit here, but I just don't know whether I should mute her. Thanks very much, Jordan. Thanks everybody for listening.
Yeah, we'll be back in about 5 minutes again at 10:30 to continue on again and take a little bit of a break here for everybody this morning.
I think Bill Thoreau, if you wouldn't mind putting your video on, because I'll just do a quick introduction of you, and then it's yours and Jordan. Okay, welcome back, everybody. It's now my pleasure to introduce a very close friend of mine and frequent collaborator, Mr. Bill Thoreau. Bill is the General Counsel at the University of Kentucky. He was Solicitor General for the Commonwealth of Virginia for a few years. Bill and I came to know each other through our activities at the Educational Law Association. We are both past presidents. Bill will be president of one of the National Education Finance Associations, I think next year. And he's also spoken and written widely on many topics involving religious freedom and particularly higher education. So with that, I turn the time over. Bill's going to speak for, I guess, about an hour, maybe a little bit less. Then we're going to have a reaction from Mr. Bill Fisher. Then we'll open up for questions until about noon. And I think Jordan will come back in later to moderate the question. So Bill, it's good to see you again. And welcome, and look forward to hearing what you have to say. And I'm going to mute myself so you don't have to hear anything in the background. Thanks.
Thanks, Charlie, for that very kind introduction. It's always a pleasure to participate in the University of Dayton's Education Law conferences. I wish we could all be there in person. Perhaps next year we will be able to do that. I speak today in my personal capacity and not as General Counsel for the University of Kentucky. So nothing that I say constitutes the views of the University of Kentucky unless you think it's particularly brilliant, at which point it is, in fact, the views of my boss, Eli Capilouto. With that, Jordan, can we go ahead and share the screen and bring it up? Okay, great. Yeah, there we are. Title of my presentation today is Toward a Confident Pluralism, the Higher Education Implications of Espinoza and Our Lady. Espinoza is, of course, the case that Charlie was talking about. Our Lady is a second case. Next slide, Jordan. What my phrase was confident pluralism, which comes from Justice Alito's dissent in a case called Christian Legal Society versus Martinez, which I think Charlie and I both agree is the worst opinion of the 21st century and quite possibly the worst religious freedom decision in the history of the United States Constitution. In effect, the court held that a university could force student religious groups to accept non-believers. So in other words, a Jewish student group would have to accept Muslims. A Roman Catholic student group would have to accept Protestants. The objective of this university was to bring people together. Justice Alito, writing for three of his colleagues, so a four-justice dissent, quoted a brief from a conservative gay group. And the conservative gay group really didn't like Christian Legal Society's viewpoints, but they recognized that if they could be censored for their viewpoints, then so could the conservative gay group. And they said, look, there's a better way to achieve these goals. And achieving the goals is for everybody to be confident in their position and to interact, a confident pluralism that conduces to civil peace and advances democratic consensus building. Jordan, next slide. Now, although this was a disaster for religious freedom, a law professor at Washington University in St. Louis, who also has a double appointment as a professor of religion, has taken the phrase and turned it into something positive. And this is John Inazu, and he calls this concept confident pluralism. Rousseau once said it's impossible to live at peace with those we regard as damned. So in other words, if you vehemently disagree with somebody, you will end up having violence. Certainly we see this in places like Rwanda. We saw this for some time in Northern Ireland between Catholics and Protestants, people who have just so many fundamental disagreements that they are unable to function as a society. Inanzu rejects that and says it is possible for us to live together even with deep differences. Jordan, next slide. And Inazu says that we must have three constitutional commitments: freedom of association. So in other words, we get to choose who we associate with. He would never force a particular religious group to admit somebody who was a non-believer. He would not force the Democrats to admit Republicans, and he would not force Charlie Russo's New York Yankees fan club to admit those of us who actually favor the Boston Red Sox. He thinks that there ought to be a space for speech and government funding of expression. Jordan, next slide. More importantly, Inizu talks to us about what we can do as individuals. He says that we should interact with other people with a spirit of tolerance, a spirit of humility, a spirit of patience. He talks about a speech imperative and essentially says, although we can say anything to anyone, we really need to guard our words, okay? It's not necessary to insult anyone. It's not necessary to have a conversation stopper. Jordan, next slide. So my thesis is that although the Supreme Court went the other way in Christian legal society, the court's most recent decisions in both Espinosa and Our Lady represent an embrace of confident pluralism as articulated by Inizu. After this, it applies to student religious organizations at public institutions, and private religious institutions must be treated the same as private secular institutions and can maintain their religious practices. And over the next few minutes, I hope to convince you of this. First, I want to talk a little bit about Espinosa. This will be sort of a quick version of some of the things Charlie said. Second, I want to talk about Our Lady. And finally, I want to talk about the higher ed implications for that. Okay. First, with respect to Espinosa, as Charlie said, beginning in the 1880s, we had state constitutional provisions which prohibit aid to religious organizations. So you could not fund a Catholic K through 12 school. You could not fund a Catholic university, such as the University of Dayton. Montana, as Charlie mentioned, provides financial assistance to private secular schools, but not to private religious schools. Group of parents challenge that denial. Jordan? The lower courts, as Charlie mentioned, ruled state trial court ruled in favor of the parents. State Supreme Court reversed. It gets to the U.S. Supreme Court. Next. Thanks. Once we got to the Supreme Court, the court built upon a case called Trinity Lutheran, which Charlie and I have written a great deal about. In Trinity Lutheran, the Supreme Court held that the religious clauses required the state to include religious programs in a grant program to fund playground safety. It says it was limited to the particular fact, but many commentators, including both Charlie and myself, thought it was significantly broader. We viewed Trinity Lutheran as essentially standing for the proposition that if the government chooses to fund particular private organizations and their activities, it cannot exclude religious organizations simply because they're religious. Jordan? The Supreme Court expanded religious liberty there, said the fact that there's no real reason to exclude religious organizations. Jordan? And in Espinosa, the court effectively destroys the Blaine Amendment. The space between what the Free Exercise Clause requires, respect for religious practices, and the Establishment Clause prohibitions is significantly narrowed. Justice Thomas's concurrence says that the Establishment Clause either does not apply to the states or simply prohibits coercion, perhaps a preview of things to come. Okay, Jordan? In Our Lady, Our Lady was consolidated with another case. Both cases involved teachers at Catholic elementary schools. Both were fired. According to the schools, both were fired for performance reasons. Both of the teachers claimed that their terminations were discriminatory. Next slide. The lower courts, in both instances, the district court said that the ministerial exception applies. Now, the ministerial exception is a notion that was originally rooted in Title VII law, but later came to be rooted in the First Amendment. And that says that when an individual is considered a minister by the religious organization, then the anti-discrimination laws do not apply. Okay, so both schools argued that these Catholic elementary school teachers were in effect ministers, were imparting values of the Roman Catholic faith. The district court in both cases agreed with them, but the Ninth Circuit reverses, saying that the teachers were not a minister under U.S. Supreme Court precedent. Jordan. Earlier in the mid-2010s, the Supreme Court, in a case called Hosanna-Tabor Evangelical Lutheran School versus EOC, they focused on the characteristics of the teacher's job. They found the teacher to be a minister. Clearly, she was under church doctrine. Justice Thomas said, yes, we agree, or I agree, she is a minister, but said, you know, we really should always defer to the religious organization's determination as to who is and is not a minister. Justice Kagan concurred and said, we shouldn't defer, but we should focus on what they actually do. If you're imparting religious beliefs, that's there, but if you're just teaching calculus, maybe not. Jordan. The Supreme Court, however, in this case, developed a new standard. They said, look, a variety of factors are relevant. You don't have to have the title of minister. That's a big departure from Hosanna-Tabor. Academic requirements may or may not be relevant. In other words, are you actually educated in theology? What really matters, however, is educating young people in their faith, inoculating its teachings, and training them to live their faith as responsibly as possible. Jordan. The Supreme Court, although they didn't say it, effectively adopts a standard of deference. For all practical purposes, I think the decision effectively adopts Justice Thomas's deference position. If the religious body says that this person is a minister or meets the requirements, is inoculating the faith, and if they're consistent in that application, I don't see the courts second-guessing the religious institution's determination. Courts have always justifiably been reluctant to get into questions of religious doctrine, who is and is not. They're not going to determine that, gee, that's not Catholic, or gee, that is Catholic. So I think you're going to have some significant deference. Now, I'd like to turn to the higher ed implications. I want to talk a little bit about private institutions and then also student religious groups at public institutions. So let's begin with the private institutions. Private religious institutions such as the University of Dayton, I think there are two broad implications. One is what the institution wants to teach and how it is going to teach it, and then two, an exemption from employment laws. Okay, Jordan? What the institution wants to teach. Charlie and I have had some discussions about Our Lady. I think it's fair to say, based upon our discussions, that Charlie likes the test and agrees with the test, but thinks on these particular facts, the court got it wrong. In other words, that these two elementary school teachers should not be considered to be inoculating the Catholic faith. And as near as I can tell, based upon our discussions, Charlie comes at this from the point of, how does the Roman Catholic Church really sort of define ministers and their role. And Charlie may very well be right there. I don't pretend for a moment to be an expert or even to understand Roman Catholic doctrine. Yet, as a Protestant, I can tell you that sometimes Protestant churches take a much broader view of what is and is not religious. And I think this is also true of other religions, particularly Islam. The institution may decide that all aspects of life are bound up in religion. And if you do, then the institution may draw the boundary anywhere it wants. And I use, in effect, two examples. One is my wife's alma mater, Wheaton College in Illinois, which is also the alma mater of Billy Graham. At least when my wife was attending there, they required the janitors to sign a statement of faith and to agree with their broad statement of faith. Another example is Calvin College in Grand Rapids, Michigan, founded by the Reformed Church in America. Calvin believes that everything we do is for the glory of God, and they've actually said in their recruiting literature that includes what we do in the labs and how we shoot a jump shot. So at Calvin, everything is about religion and furthering God's glory. Now, if you believe that, then all of your faculty become responsible for this. Most of your student affairs administrators, because your student affairs administrators are involved in education, certainly the coaches, if we're shooting jump shots for the glory of God, then the coach is in effect inoculating those values, and potentially senior administrators. Okay, Jordan, next slide. So if the religious institution says all of these individuals are educating young people in their faith, in inculcating its teachings and teaching them to live their faith as responsibilities, then that position is exempt from employment laws. So in my last example, we have, Calvin College basically can exempt pretty much, if I understand their doctrines correctly, almost their entire employee staff. Same thing for Wheaton. And I think you're going to see more and more of this, particularly with Protestant institutions, maybe to a lesser extent for the Catholics. Okay, so that then brings us to Bostock. Now, Bostock, as you know, has been called the rewriting of Title VII. But what we essentially had was Justice Gorsuch applying textualism, came to the conclusion that the word sex, as used in Title VII, includes both sexual orientation and gender identity. Thus, an individual cannot be fired simply because they are a homosexual, nor can an individual be fired because they were born biologically male or biologically female and now identified with the other sex. It is obviously a significant victory for the LGBTQ community. It essentially eliminates discrimination against them in the private sector, since virtually all employers are subject to Title VII. However, it is inapplicable to those positions that would qualify under the ministerial exception. So a private school, religious school could say that. We're not going to hire someone who is gay. Let's talk a little bit about student religious groups at public institutions. Student religious groups have essentially three broad rights. One is the right of recognition. That is, if they come together, have a faculty advisor, have their nominal constitution, they get recognized. They have, Jordan, next slide. They have a right of access. They have a right of funding. If the school chooses to fund people, they have the right to ask for money, just like the Democrats or the Republicans or the Yankee fan club, and they have some associational rights. But there are some limitations. As I alluded to earlier, Christian Legal Society says that a public institution may force student religious organizations to admit those who disagree. We also have some limitations on funding rights. Public institutions say, well, we're not going to fund worship or proselytizing. Thus, you might have a situation where the young Catholics are not allowed to buy bread and wine because a priest will consecrate those and turn it into the Eucharist. But the French club can buy bread and wine. We might say, we're not going to send you to another city for the weekend so that you can go door to door and convince people to join your religion, but we will send the young Democrats or the young Republicans to another city so that they can go campaigning. These types of things have actually happened. But Espinosa and Our Lady, I think, changed that. Espinosa suggests that if an institution chooses to fund the expenses for secular groups, it cannot refuse to fund the same activities for the religious groups. So if you allow the French club to buy bread and wine, you got to allow the young Catholics. If you allow the science fiction club to buy books, then you've also got to allow the Scientologists to buy L. Ron Hubbard's books and other people to buy the Bible or the Quran. Now, we also have the problem of Our Lady with Christian Legal Society. Our Lady seems to be saying that you get to choose who your leaders are. If you choose your leaders, you also obviously get to choose your members. But Supreme Court decisions can never be overruled by implication. So Christian Legal Society remains good law until overruled by the Supreme Court. I think there is a way to potentially limit it. But a religious group would have a strong argument that a state university cannot interfere with the group's internal policies regarding membership and leadership. And I might also mention here that if your state has a Religious Freedom Restoration Act, and I believe a state law to that effect, and I believe Ohio does, it's going to be tough. The religious group already has this right. And in Kentucky, in addition to the State Religious Freedom Restoration Act, we also have a state law that says the state universities cannot interfere with the internal organizations of a religious or political group. So what does this actually mean? Well, I think what we're seeing is the court beginning to put out a vision of America. The court's expanding secular protections against discrimination, okay? If you look at where the LGBTQ community was in 2010, or even 10 years earlier, 2000, before Lawrence versus Texas, with where they are now, the court is effectively saying it doesn't matter that you are gay or lesbian. You have the full right to participate in American life. You're not going to be fired. And although your particular church may choose not to have same-sex marriage, to the extent that the state provides benefits of civil marriage, the state will extend those benefits to same-sex couples. But at the same time, the court is also expanding religious liberty. I actually think that Trinity Lutheran and Espinosa are for people of faith the equivalent of the gay marriage decision of Obergefell versus the state of New York. The court is essentially saying people of faith will not be second-class citizens. Now, that does not mean that private religious schools get funded. It does mean that if the state chooses to fund private schools, religious schools also get to play. So you cannot be shunted to second-class citizens simply because you are a person of faith. And the Blaine amendments, which were born out of bigotry, have been eliminated, just as statutory prohibitions just as we've extended statutory prohibitions for sexual orientation. So where does this actually seem to be sending us? Well, I think it sends us to Inazu's confident pluralism. The world is wide enough that people of faith and secular people can exist in American society and can fully participate in the debates and the discussions. And we can each live our faith, our lives, and pursue the values that we want. And in all honesty, at a time when our society seems divided as never before, I'm hoping that the court's message is one toward a large degree of civil peace. Jordan? And with that, I'll be happy to take questions. If I don't get to your questions today, I can be reached at the contact information there. I'm also on Twitter at William Throw. I do not tweet a great deal. My papers are also on the Social Science Research Network. So it's possible that we have some questions, and I know Bill Fisher is going to have some interesting comments as well. So I'm not sure if we go to questions or if we go to Bill right now. I guess we go to Bill since I see Bill.
Yeah, I think we'll go to Bill, and then we'll take questions for both of you afterwards. So again, everybody, if you want to submit questions down there, you can use that Q&A feature, and we'll get to those after Bill Fisher's presentation. And Dean Lori Shaw is here to introduce him.
And it is my pleasure to introduce Bill Fisher, who is the university's Vice President for Student Development and has been a friend of mine for many years. Bill, as Vice President for Student Development, literally touches every legal issue, I think, relating to students that comes to UD, and he is nationally known for his expertise. I want to thank you for coming today, Bill, and I look forward to hearing your response.
Lori, thank you. Thanks for that kind introduction. So I thought really what I would do was just make a few comments, and then I certainly have a couple of prompting questions that hopefully the audience will pick up on. So I will tell you that the Our Lady decision I found to be pretty fascinating. As Lori indicated, I've been the Vice President for Student Development at the university for a number of years, going on 10 years. I've worked in the division for 12. And when we look at this ministerial exception, we have some guidance from the Supreme Court. And yet at the same point in time, the court seems to indicate that they're not going to adopt a rigid formula for deciding when an employee qualifies as a minister. And so, it certainly leaves the question, as the court indicated, really, you need to focus on, it matters what the employee does. So I was struck by, Bill's PowerPoint presentation, and particularly when he listed the different groups in an institution, a Catholic institution in which he includes student affairs. If you take a look at our mission, right? And again, this is a provocative question, but if you take a look at our mission in the Division of Student Affairs, our first sentence reads as follows: the Division of Student Development cultivates student learning in the Catholic and Marianist tradition. So what that means is that every department in the division is responsible for the holistic development of students, teaching students, learning students based on learning outcomes, but all in the foundation of our Catholic and Marianist values. And as a matter of fact, we have a document that exists called the Commitment to Community document. It is a document that we share with students, which basically teaches them principles and habits of community living. All of the tenets, all of these principles and habits, again, the foundation of them are based upon the university's Catholic and Marianist values. And so much of what the division does and so much of what each department does really focuses on this holistic development of students in our Catholic and Marianist values. And so, I couldn't help but think to myself, well, certainly, when you look at this on a case-by-case basis, what does that mean for the ministerial exception as it would apply to student affairs divisions, not only just at the University of Dayton, but at any faith-based or Catholic institution, across the country. So again, it matters what an employee does. I think one of the other things that I wanted to just mention is when we look at the ministerial exception, the court certainly has spoken. And yet it has also indicated that it won't apply a rigid formula, which leads me to believe that these matters will be decided on a case-by-case basis. Others may disagree, but I think that that will mean in the future is that the lower courts will have to wrestle in future cases as to where when the ministerial exception applies, certainly, and what it does and when it doesn't. I also thought to myself, I was reading as I was doing some more research beyond just the Supreme Court decision itself, I came across a piece that was written by an attorney, Taylor Eric Wright, who's senior counsel at the law firm of Foley and Lardner, which is an international firm. And he spoke about, one of the takeaways for religious employers. He spoke about some things that institutions may want to think about including in some of their documentation as part of, ensuring that the ministerial exception applies. So, for example, what do we put in job descriptions? What do we put in employee handbooks? Should there include statements in both of these documents about the university's religious mission and the employee's role in that mission? And I think that's really critical, right? The employee's role in that mission, because that's what the Supreme Court spoke to as it relates to this ministerial exception. I would say the same thing, and picking up in his article about if there's any formalized employment agreements. What should be put in the employment agreement that ties the role of the employee to the mission of the institution in respect to the daily functions or daily duties of that particular employee. What about performance reviews? Employee performance, how do we tie that to the mission of the institution and the role that the employee plays in terms of furthering the mission of the institution and ensuring that we're making sure that the employee plays a vital role in the religious mission of the employer. So I found this decision to be pretty fascinating in terms of its potential impacts down the road, as lower courts will have to continue to wrestle with this. I often wonder about what would be the fact pattern that would exist where perhaps the ministerial exception would not apply. And so certainly I think that remains to be seen. And so the other thing I just wanted to point out was, Bill had spent some time on Espinoza, and Charlie obviously went through a detailed explanation and analysis of Espinoza. But clearly, I think in that particular case, it's somewhat of a landmark victory for school choice advocates, really allowing the parents the freedom to choose the best school for their children, And yet you have opponents out there that say that it has a negative effect on an already underfunded public schools by diverting some of this money to religious schools. I often, one of the things that was mentioned, I think, by Charlie was, the fact that there's at least 37, maybe 38 other states that have these Blaine amendments that are like in their constitutions. So the question I think we have to ask ourselves is, what is now the effect or the impact of those Blaine amendments? Obviously, it seems to me as though they're severely diminished, but how will how will that be dealt with in the future? So the Institute for Justice that was a part of the work that went on in that previous case, what will they do in terms of seeking to strike those amendments? Those are some questions that certainly come to my mind. And so with that, I thought that that would be just some opening remarks that I would make, some takeaways that I had. And again, when we go back to Our Lady, the decision of Our Lady, I think it's a really interesting case in which you can think of a variety of fact patterns in which perhaps the exception wouldn't apply, or perhaps the exception would apply. So based upon those, opening comments, certainly would welcome questions about, the impact of these decisions, in particular Our Lady of Guadalupe. So with that said, I would say we could open it up for questions. And I'm not sure how best to do that. Jordan, I guess that you'll facilitate those.
Yes, yeah. Again, if anybody has any questions, just type them into the Q&A feature there at the bottom of the screen, and I can ask them to Mr. Throw and Mr. Fisher. First of all, I guess something that you could both possibly weigh in on, and somebody has an interesting question of a test case of what it would mean. They want to know, so if an unmarried woman at a religious school, could she be fired for becoming pregnant if the religious school didn't allow sexual relations outside of marriage? And what about an unmarried male wouldn't necessarily have any issue because there wouldn't be any way for the school necessarily to be able to tell or track or whatever? What happens in a case like that, or do you think would happen in a case like that?
Well, assuming that the teacher qualifies for the ministerial exception, and I really hate the term ministerial exception. That's what developed in the lower courts, and the Supreme Court sort of said we're stuck with it. But assuming that the teacher's position qualifies as, this is part of our religious mission, we're doing, the religious autonomy, and the school has made it absolutely clear that sexual relations outside of marriage are forbidden, then I think the school wins. I would hope that as a matter of comedy, that the school would treat the male who impregnates someone outside of wedlock in the same way. Obviously, that is much more difficult to prove, at least until before the child is born. But I think the bottom line is, if the teacher's position qualifies for the so-called ministerial exception, then yes, the school would be able to terminate.
I think Professor Russo, you wanted to weigh in as well.
Thanks, Jordan. Thanks again, everybody. A few years ago, I don't remember when it was, I was at Holy Angels Church. We happened to worship there, and I was in the sacristy because I took care of lectors, and this very question came up. There'd been a newspaper article here in Dayton, and I don't remember the Catholic elementary school, where a teacher was dismissed for being pregnant out of wedlock in a Roman Catholic school. I would just add to what Bill said, and I agree with everything. It's also a matter of contract, because there's an issue going on for those in the area at Alter High School, where an administrator acknowledged that he was in a gay relationship, and I believe his contract was not renewed. I think there's some litigation, but I haven't seen it go forward. But at least with regard to the female teacher, I came in, I was talking with a priest, and a parishioner came back in and raised these issues. and raised the same question as, what about the guy? What about the male? And my response, interestingly, was the same one that was printed a couple days later in the Dayton Daily News by the spokesperson for the diocese. He said, if she had been impregnated by a male teacher in one of our schools, we would have dismissed him. But if he does not work for us, we really have no authority over his actions if he's a non-employee. And most Catholic school contracts, for what it's worth, and just yesterday I had a 90-minute conversation with the president of the National Association of Catholic School Teachers, a National Catholic Teacher Union. I do some work with them. And we were talking about these issues. And many schools now are including in their contracts, and they give the teachers a copy about an inch thick, the Catechism of the Roman Catholic Church. They give them a copy of that volume, and there's language in their contract saying that I agree to abide by all the teachings of the Roman Catholic Church as expressed herein. And so if somebody has agreed to do that, I think it's also could be a matter of contract. But if the male teacher, and I worked with male teachers years ago, that I was amazed they were allowed to keep teaching in a Catholic school for the stories they told in the faculty room. If I were in charge, they would have been gone. But I think under today's regime, they would be gone. I hope that helps to give some background on it just a little bit.
And just some clarity on the altar situation. Somebody writes in that involved an English teacher whose marriage license for his legal same-sex marriage was sent to the Archdiocese by an anonymous member of the community, and that they did base his non-renewal of the contract on the minister designation in the contract.
Fair enough. I say I don't know all about it. Somebody had mentioned in class, and I read an article, news article a while back. But I do think he did not deny the existence of a relationship, even if it came in anonymously.
And then somebody else asked, we were on the topic of the issue of somebody being pregnant. What about if the person conceived by artificial insemination? Mr. Thor, anything, does that change it at all on what the school would be able to do?
I think it would depend again on the church's doctrine considering artificial insemination. If the church permits artificial insemination but does not permit sex outside of marriage, then I'm assuming that the teacher is going to be able to prove that it was artificial insemination. But the bottom line comes down to, for those people who fall within what the court is calling the ministerial exception, what I would call religious autonomy, for those people who are in those critical positions, then the religious organization is going to be able to say, you will abide by our teachings. Hopefully, and they will do what has been recommended and clearly and unambiguously articulate what those expectations are. That's certainly the advice that I give on a pro bono basis to private religious schools. But assuming that the doctrines are clearly articulated, then yes, they're going to be able to take actions on it.
And there is somebody who, yeah, go ahead, yeah. There was somebody who mentioned a case that the Cincinnati Diocese lost where the person said they didn't realize what they were let go for was against Catholic doctrine, and apparently after that they changed the contracts to make it more explicit. So I guess, as you mentioned, does that factor in as well as to, whether somebody should or shouldn't know about what's allowed or not allowed?
Well, I think Charlie gives an excellent example, where they say, we are expressly incorporating all of the prohibitions in the catechism, or, here is what you are allowed to do, and here is what you are are not allowed to do. But assuming that it has been explicitly said, then I think it's fair game that you violated it, and you're out. Yeah, it gets. I mean, we sometimes, particularly in some Protestant denominations, get into really parsing statements of faith, and what does this particular phrase mean, and is it acceptable to believe this but not that? But I mean, again, that's up to each institution. If I'm running a Roman Catholic seminary, then I probably don't want somebody who rejects the teachings of the Roman Catholic Church, even if that individual is, high up in the Orthodox church, or high up in a Protestant church.
I know we keep getting questions of people kind of wondering about the extent of that ministerial exception. They wanted to ask if like an interracial marriage was prohibited and somebody married somebody from another race, if that would, apply under that.
I again, assuming that the position in question qualifies, and assuming that they are clear, that then yes, it would. I mean, I use an example from a couple of years ago that was decided on some slightly different contractual basis, but think about this. A professor at my wife's alma mater, Wheaton College, got into severe trouble and eventually left after she publicly stated that she wanted to wear the Muslim hijab, and she did so because she wanted to be in solidarity with her Muslim friends, and she stated that Muslims and Christians worship the same God. And that particular iteration or phrasing, Wheaton College found to be contrary to Wheaton's statement of faith. We can debate that, but they're allowed to decide what they believe and what they don't believe, and they're allowed to decide that what you did is contrary to what we believe, and therefore they take the actions to make sure that the people who are educating their students are consistent with their beliefs.
All right. A question for Mr. Fisher. Somebody wants to know what the University of Dayton contract states in relation to, as they put it, extramarital actions.
I don't know, to be frank. So that's not. I mean, I don't know.
Okay.
I did have a question for Bill.
And that's reassuring that you are unaware of.
I did have a question for Bill, if I may.
Sure.
Bill, in your presentation, you mentioned one of the schools, I forget the institution, and you had indicated that based upon what was in their documents, that arguably any employee at that institution could qualify for the ministerial exception. I forget which institution it was. But in any event, I think about that, and I think when we say arguably could apply to every employee, would that be anybody from a faculty member to a senior administrator to a groundskeeper to someone in dining services? Just curious about your thoughts on that.
I think it's real tough to make it on dining service on groundskeepers. I think you could make a more of an argument with respect to dining services, that you're interacting with the kids and that sort of thing. I think it's tougher on janitors. I think it's real easy on people in your field, although I will say I was surprised at some of the statements in Dayton's things as opposed to some of the to some Protestant schools. I think it's real easy for coaches, and there are also sometimes requirements on senior administrators. Early on in my career, I interviewed for a position as an associate general counsel at a Jesuit institution. I'm not Roman Catholic, and they told me that that was fine as long as I did not actively go against Catholic doctrine, in particular the abortion issue, and my views on abortion are consistent with those of the Roman Catholic Church. So, that wasn't a problem. But I mean, it's not unusual at private religious schools to have the senior administrators, the general counsel or whatever, to have to sign a statement of faith, or to say that you have a role in that way. Would not be surprised if every private religious institution suddenly starts rewriting their contracts and defining things as broadly as possible.
Thanks for that insight.
And sort of related, somebody again mentions that their husband taught at a Catholic school, and that they said in the contract, it was pointed out that if his wife was taking birth control, it was against the teachings of the Catholic Church, and that I guess he could be let go in a circumstance like that. So I guess again, people are saying that it goes to what you're saying, Mr. Throw, that schools and diocesan people are expanding kind of what they determine, what they want people who work for them to believe and follow.
Yeah, and it's my knowledge of Roman Catholic doctrine is that artificial means of birth control is prohibited. So I could see the school saying that, unless you asked someone and they answered honestly. I'm not quite sure how you would figure that out, but
Yeah. And Professor Russo, I think you had a question or for
Thanks,
Mr. Fisher,
George.
Mr.
I did have a
Thoreau.
question, but on that comment about the situation with the birth control, there was an unreported case from Westchester County, New York, probably 20 years ago. A woman teaching in a Roman Catholic school had not herself been married, but she married a man who entered into a non-Roman Catholic marriage with a Catholic. It was a non-sanctioned marriage. He didn't get exceptions. They received a civil divorce, but not a civil annulment, and she was dismissed for failing to get the religious annulment of her husband's first marriage before she entered him. And the court threw the case out. So essentially the school won. Personally, I think that's going a bit far. She went about as far as she possibly could have, and she hadn't done anything wrong. I think that's wrong interpretation. But those things happen in terms of the courts, I mean.
Well,
I did have a question for the two bills, unless you want to go first, Bill, go ahead.
no, just expanding a little bit on what Charlie said. Each institution is going to be able to define for itself its internal policies, what its rules are. And, I agree with Charlie that the situation that he just described is a bit too far, but, that's my opinion. If that's what the leadership of the school or the leadership of the denomination, how they want to draw the line, I think the courts are going to defer to them. So I'm sorry, Charlie, go ahead.
I did have a question for you and Bill, and I know you, Bill, and I have talked about this, but in Guadalupe, neither of the teachers even had to be Roman Catholic. So I wonder how you make them a minister. And if you compare the facts in the earlier case in Hosanna Tabor, the woman who was a call teacher in Hosanna Tabor received additional tangible benefits. Parking, she had to have so many hours in theology from an accredited Lutheran institution, different pay, and she received much greater procedural due process rights in the event she were, as she was, ultimately to be dismissed. I can't help but to think that's an awfully wide stretch not having to be Catholic and not getting any additional benefits to be included under that ministerial exception. I just wonder why they didn't take the ordinary labor standards, or labor steps rather, of simply non-renewing the one woman's contract for cause. The second woman, not Guadalupe, the other case, died of the cancer she missed time for. She might not have been a very good teacher, but why did they not document it on the basis of not performing well? If nothing else, it paints the Catholic Church, or any faith, in less than positive light to dismiss a teacher under those circumstances. And then when you throw in, as you and I have talked, Bill throw, they don't receive nearly the same benefits. Catholic school teachers make considerably less than public school peers, and she was not even required to be Catholic. How could she possibly be held to the standard of being a minister of a faith she neither believed in nor practiced, particularly as a faith formation person working with younger children, as they both did? Any thoughts or comments from you guys? And I'll shut up.
I think you make some good points. I think the response is what is in the Justice Thomas concurrence, which I think is probably the future, and that is we are going to defer to the religious institution. It's unusual that you claim someone is a minister when, or has all this important role in religious benefits, even though that person doesn't adhere to the faith. But I think the church can take that standpoint. One thing that people frequently say is, okay, it's one thing to be a teacher of religion or theology or Bible. It's another thing to be a teacher of math. But one of my favorite theologians is a Dutch gentleman named Abraham Kuyper, who died in the 1920s. But Kuyper believed that there was a Calvinist or Reformed theologian perspective on everything, on math, on art, on biology. Now, unfortunately, he never quite developed exactly what it is about Reformed math, other than perhaps the answers are predestined. But if you take that view that all of life is there, then your math teacher is religious. And I think, in all honesty, my understanding is Calvin College in Michigan comes close to that. And if I've gotten that understanding wrong, I apologize. I'm just going on perceptions. So
I think, Charlie, it's a great question you ask about, if the instructor or if the teacher doesn't happen to be Catholic, right? That was one of the questions that you asked. And so for me, it causes me to wonder, when the courts are going to do this kind of analysis, is the focus going to be on whether on looking at that person's religious background, or is it going to be an analysis based upon the factors that were identified in the Supreme Court decision? That is, it's a religious institution, the person is performing functions that are directly tied to the mission of the institution, regardless of what that individual's faith may be. So that's what I am wondering about. And I would think that perhaps the courts would look more towards what the function and the role is of the individual, and how effectively are they carrying out as it relates to supporting the mission of the institution. That's just my gut sense.
Thanks, Bills. And I hear what you're saying. Thank you for the thoughtful responses. But I wonder then if the job descriptions are accurately defined.
Well, that goes back
If
to the issue.
if anybody can be hired, but then not retained, isn't it fair or just to use some of the Catholic Church's words? And Bill knows I wrote a column for a place where he's been writing as well, that really takes the church to task for not keeping up with its own teachings on labor justice in the church. Let people know what the rules are before they get started.
And I think it is absolutely important for any religious institution to make it absolutely clear what is expected and what is not expected, and it seems very unfair to fire the unmarried woman for becoming pregnant. But I think that's why it's important to say early on, when she goes to work, look, these are our expectations. And, if you become pregnant out of wedlock, or we find evidence that you're having sexual intercourse out of wedlock, this is the expectation. And if she chooses to agree to those things, then, hey, those are the consequences. But I don't think we should be in a situation, and the courts will probably be reluctant to allow the religious institution to make something up after the fact. I've been teaching here for 10 years, and suddenly you've decided that premarital sex is wrong.
All right. Again, anybody, if you have any questions, just submit them. You've got the Q&A feature down there at the bottom. I guess for Mr. Throw, Mr. Fisher, what do you see maybe on the horizon? I think you touched on it a little bit, but what could be next, in these areas of law, as far as, kind of where cases go, where the law goes? What do you kind of see?
I would just say, starting out, when I think about the Espinoza case, what is the impact of the other 37, 38 states in terms of their Blaine amendments? So what's the future there? And then, as I previously said, the court decided what it decided in Our Lady and kind of set the parameters and set the standard, but how will the lower courts then take the analysis, how will they analyze cases that come before them in the context of the parameters that have been set forth and identified by the Supreme Court? That's just my initial thinking.
Yeah, I think I generally agree. I think the Blaine amendments are dead, and here's why. I think any state or local government in the country that creates a program that is open to private secular schools or private secular institutions, daycare centers in the case of Trinity Lutheran, and excludes a religious group because they are religious, I think you're going to lose. And I think Institute for Justice, Beckett, ADF will come in and support those. I guess we could have some situations of religious discrimination as a sort of pretext. So let's take Trinity Lutheran, where there was only a finite number of grants, and it was clear that Trinity Lutheran was denied because they were religious. But suppose there's 5 grants and you made a grant application and you finished 6th, and you argue that really we would have finished 3rd, but they knocked us down because they're religiously biased. I can see cases like that. I think those cases ultimately turn on the facts. I don't see any state being able to say we're denying you a benefit simply because you're religious. With respect to Our Lady, I think the next cases are going to be those where the schools have not been clear as to what is expected. So in other words, we're going to fire you for using birth control, but we didn't know that you never knew that, similar to what happened in Cincinnati, for example. And then I also think some cases that are sort of in Bill Fisher's domain. Okay, teachers are going to qualify for ministerial exceptions. What about student affairs administrators at a Roman Catholic school, because based upon what Bill told me about the contracts and their position statements, I can make a real strong argument that your folks are responsible for inoculating the faith. Now, whether or not the leadership of the university wants to go along with that or is a different matter, and that goes to Charlie's thing about the church drawing the lines at particular places. But I see some coaches, student affairs, administrator cases being mixed up.
All right, thank you. I think Professor Russo, you maybe had another question or so, and then we'll take our break for lunch.
Thanks, sure. Just a speculation question based on some of the exchanges that both bills had, but in response to a question from the audience. The question dealt with interracial marriage. I wonder how you'd respond to that in light of Reynolds, the first time the Supreme Court used the wall of separation, where they basically struck down the polygamy rule despite the fact that it was part of the teachings of some of the Latter-day Saints, and the person was apparently not a minister. And then Loving v. Virginia, which banned the prohibition of interracial religion. Do you think a religious prohibition could stand in light of those two cases, religious freedom notwithstanding? Just a speculative question to give some people something to think about. What do you think? Either or both of you? If it were challenged, would it stand?
So to make sure that I understand this, the church, the religious organization, the church, has a requirement that you are not allowed to marry someone of another race.
I believe that was the original question, yes.
Yeah, okay.
And I didn't raise it, but I'm just pushing it further. In light of Reynolds and then Loving, could that survive scrutiny? And even strict scrutiny?
Yeah, I think so, because I don't think there is, I think Loving's inapplicable because there's no governmental action here. What you have is a private religious institution deciding to, in effect, discriminate on the basis of race, because presumably it's okay for the African American teacher to marry an African American, but it's not okay for the white teacher to marry an African American. So the two similarly situated teachers are being treated differently based upon their race. Now, that would clearly be a violation of Title VII unless the ministerial exception applied. And in this hypothetical, we're going to assume that the position is covered. So I think they ultimately prevail. And, you know, we've been dealing with some hypotheticals that seem, you know, really unfair, really unjust. But, you know, I think where the court is going is they are going to allow the religious institutions to order their own affairs and not really interfere, other than perhaps banning human sacrifices or something like that. But at the same time, outside of the religious sphere, there's going to be little or no toleration for discrimination of any type.
Just back it up a little bit, though. Remember Bob Jones, the original one Bob Jones case, they lost their right to grant tax deductions or what have you on taxes. Would that bring it under the auspices that they could still try to prevent it if they want to receive those governmental benefits?
That's a really interesting case, or a really interesting hypothetical. I believe Bob Jones was wrongly decided, although I obviously abhor the beliefs that Bob Jones had on the religious viewpoint. But, you know, what it amounts to, Charlie, in your hypothetical is can the federal government, as a condition of receiving federal funds or receiving some sort of benefit, a tax benefit or funds, require a religious organization to change its core religious beliefs? And I mean, the easy one would be to, obvious one would be to say, as a condition of receiving federal funds for any purpose, the Roman Catholic Church must allow women to become priests. And I think we would all say that's absolutely outrageous. And despite Bob Jones, I think the current court would agree that that's absolutely outrageous and find it unconstitutional.
But is there a distinction between not ordaining women based on a 2,000-year tradition that extends earlier to Judaism with something that has already been struck down in civil context? Misogyny is not acceptable in our society.
I think where the court is going is an absolute right of you to believe whatever you want, and then to associate with other people who believe the same way, and for that organization to order their internal affairs as they see fit, consistent with that with that belief. And that will cause a lot of things that I find personally offensive and that you find personally offensive. But I think that is the price of the special solicitude that we give religious organizations under the religious clauses. And quite frankly, I think that is something that we should preserve.
Fair enough, but throw Reynolds back in there. You can believe what you want as long as you don't violate the law.
Well, Reynolds in polygamy may be the next area. Certainly many churches don't believe in polygamy. No state, to my knowledge, recognizes polygamous marriages. Will that change in the future? Perhaps so. Certainly, every state in the union will allow two people who have been previously married to other folks and who have acquired a civil divorce to get married to each other. My understanding of Roman Catholic doctrine is if one of those folks is a Roman Catholic, the church will not recognize that marriage. And I think the church has the absolute right to decide for itself whether or not it's going to recognize that marriage.
I agreed on that, but that's if you want to be a member.
Right.
There's no obligation to be a member. And I have seen, and I cannot give you citations, but you probably have as well, where a number of social commentators are suggesting that polygamy and polyandry are the next big issue coming down with the status of marriage.
Well, I think one of the arguments in the gay marriage cases was that if the government recognizes a particular, it recognizes and extends benefits, the tax benefits, certain legal presumptions, to same-sex couples or to opposite-sex couples, then it is obligated to do so to same-sex couples. If you take that logic, if the government does that for relationships involving two people, then why won't it do it for three or four? And you can argue tradition, certainly, but the reality is, if we look at all of the cultures in the world, polygamy is far more common than same-sex marriage was prior to the 21st century. Now, obviously, if we have the state recognizing polygamy, that does not mean that the Catholic Church or any Protestant church or Islam or anybody else has to recognize it as a matter of ecclesiastical law.
All right, we have another question here before we break for lunch real quick, and I think anybody could field this, but they want to know just kind of when the support for religious institutions kind of crosses the line to establishment of religion, and kind of where that line's at right now.
Let me give a real quick answer. My all-time favorite Supreme Court quote, then I'll stop.
Yeah.
Potter Stewart, 1961. You can't, talking about pornography, I can't define it, but I know it when I see it.
Uh-huh.
And I think that's where we are.
Absolutely. Thought the exact same thing.
Yeah, I think Justice Stewart's concurrence in Jacobellis versus Ohio, which I think actually came out of Dayton, is probably apt. I think I would say that the court is headed toward a coercion type test, where you force someone to actually attend services. I also think there is an interference in the governmental affairs thing. You know, in England or in the United Kingdom, where there is an established church, the Archbishop of Canterbury, there's a bishop commission or something that, you know, sends up 3 names to the prime minister, and the prime minister picks. I don't ever want a situation where President Trump, or perhaps someday President Biden, or the governor of Ohio picks who is going to lead Charlie's church or who is going to lead my church. I think coercion and just outright interference is probably where the line is. Beyond that, it's I think a lot will be acceptable that in the past would not be acceptable. But I also don't see government prescribed prayer in the public schools where the government actually writes the prayer returning anytime.
All right. Well, I think that's it then for this session. We can give everybody a couple minutes early break for. Oh, yes, Mr. Fisher, you had something?
Just a quick commentary, just similar to, just to say that, you know, my commentary here over the past half hour or so represents my commentary, my own personal views. And I just want to make it clear, it doesn't represent any official position at the University of Dayton or its Office of Legal Affairs. It's my commentary based upon my analysis of the cases and the discussion with the other panelists. Thank you.
All right.
Same true for me.
All right. Thank you, everyone, for those disclaimers. And again, we'll give you a few minutes.
Neither of them contradict church teaching, so.
We'll break for lunch here until 12:30 when we'll come back with Dean Shaw's presentation. We do have a video we can play if you want to pay attention to. You don't have to. Something our Leadership Honors student program put together, a documentary that's about half an hour that will start in a couple minutes. Again, you can mute it, turn it off, whatever you want to do with it. But if, you know, while you're eating lunch, if you're bored and you're looking for something to kind of fill the time and you leave the screen up, feel free to listen in and let us know what you think of it. But anyways, yeah, thank you, gentlemen, all for your time. And again, we'll break for lunch and we'll see everybody back here at 12:30. So thank you very much.
Welcome back, everybody. Jordan, could you could you share my PowerPoint? I thought I was going to be able to, but my computer is disagreeing with me at the moment.
Yeah, sure. Just give me a second.
Okay, this session, we're really going to be switching gears and we're going to be talking about Title IX. I wanted to start off today by talking a little bit about the history of Title IX. And as as everyone else has indicated, I also want to start off by making clear that the views that I'm expressing are very definitely my own, not necessarily those of the university, but by way of background, in 2011, when the Department of Education started requiring universities to have Title IX coordinators, I was the University of Dayton's first Title IX coordinator. So this is kind of a topic that is near and dear to my heart. Let's start off talking a little bit about the history. And I think, I don't know if Jordan heard me when I asked if he could share my PowerPoint.
Yeah, we'll have it in just a
Try
second.
again and see if I can.
We'll have it in just.
Oh, there we go. Perfect. Okay. Jordan, if you can go to the first slide, we're going to start off with a brief history of Title IX and higher ed. And actually, if you can go to the slide that follows that one, let's talk about Title IX. Title IX was created in 1972. It is one of the shortest federal statutes I've ever seen. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And I wanted to touch for a minute on how broad the application of this is. When you're talking about Title IX, over 7,000 colleges, universities, and other higher ed institutions receive federal funds. And receiving federal funds, the biggie is that includes having your students be qualified to receive federal loans. So, that's kind of the big power of the Department of Education in terms of Title IX. If a school violates Title IX, the DOE has the power to cut off federal financial assistance to students. So as I mentioned, there are over 7,000 higher education institutions to which Title IX applies. And I want you to picture what they are. It goes all the way from huge public universities like Ohio State with tens of thousands of students to beauty colleges. If someone can use federal loans to attend that institution, Title IX applies. So let's talk about just a few basics. The Department of Education is charged with enforcing Title IX, and within the Department of Education, it's the Office of Civil Rights that enforces Title IX. Title IX applies to all forms of gender discrimination, and it protects or has protected historically students, faculty, staff, and visitors. Even though Title IX itself does not mention sexual harassment is prohibited under Title IX. And It's interesting, when Title IX began, the big application that everybody saw was in athletics. When I was in elementary school, I think there was one girls' team. I think girls' basketball was the only team that was actually out there, where the boys had football and a number of other sports. You don't see that today. Title IX has had a huge impact in terms of creating equity in athletic opportunities. But if Jordan will go to the next page, now Title IX is being applied in a totally different way. And before we get to all the details in that, what I want everybody to understand is Title IX is now being implemented through campus disciplinary systems. And I want everybody to think about, what is it when you think about college disciplinary systems? Historically, what kinds of things have they had to deal with? So I put a few pictures up. On the right, you've got students who are in a fist fight. On the upper left, you can see graffiti, something objectionable in terms of causing damage to the campus. A big one that people are concerned about, things like underage drinking. I mean, that's really, when you think about campus disciplinary systems, what they have been asked to do over the years and to look at over the years. And, one of the things I want people to understand is kind of what the goals of campus disciplinary systems are. One of the big goals really is, we have young people and we're trying to educate them. If their behavior is not that which we want it to be, we're trying to educate them. But, at some point, there's also a judgment as to whether or not we think that a student can be or should continue to be a member of our community. If you have a student who is setting fires, if you have a student who is somehow engaged in a dangerous activity, that's what a campus disciplinary system is really looking at. We're trying to help students learn and grow. So a lot of what they're doing is work on helping students see the error of their ways and to rehabilitate them. But another big thing is, if there really is somebody who absolutely can't follow the rules and is disrupting the educational environment or threatening the safety of others on campus, basic idea is you can suspend or expel that person. So as we talk about how Title IX has changed, I want you to keep in mind that all of the policies and processes and structures on campus discipline have been really established to deal with things that are at the level of, gee, you have two students who get into a fight. What do you do about that? So, as I said, when Title IX was enacted, the big focus was honestly on college athletics, whether it should or shouldn't have been. That's kind of where colleges and universities thought everything Title IX kind of fit. They were, to put it mildly, shocked when they opened their mail in April 2011 and found the Dear Colleague letter that came from the Department of Education. And what the Dear Colleague letter was saying was, sexual assaults could no longer be ignored. And I think, again, with that, you kind of have to look at, and I think colleges were all over the board at that time. Some had long sought to provide relief for victims of sexual assault and sexual violence. But that's a really, really, really tall task to ask a university to undertake. When you think about the sexual assaults on most campuses, very, very, very few, a minuscule amount involve what we would think of as stranger rape. Some are date rape. These days, actually, a lot are acquaintance rape. This isn't even a situation where the two parties know each other. They typically almost always involve alcohol, and I'd say most often alcohol on both sides. They are complicated situations, and quite frankly, because of the differences in how sexual assault is defined for purposes of the criminal law versus how it's been defined for purposes of college campuses and disciplinary rules, most of the cases of sexual assault on campuses are things that would not qualify as something like rape or sexual assault in the criminal courts. A good example of that comes in terms of the use of alcohol. In most states, if you are voluntarily intoxicated, unless you are so intoxicated that you're passed out, you can't bring a claim of, or successfully bring a claim of sexual assault. Voluntary intoxication is something that kind of wipes out that type of a claim. You can't deny consent based on that. Schools are in a tough situation because they really are a place where you have a lot of young people, a lot of people who are on their own for the first time. It's kind of they're drinking, there's kind of a perfect storm for non-consensual sexual contact. And I think, frankly, for decades, schools just didn't quite know what to do with that. So it was easy to say, well, if there's a sexual assault, the student can report it to the police, or the student can bring a civil action. So I don't think that universities were necessarily jumping into dealing with sexual assault with both feet. But Dear Colleague letter changed everything. It said, campus, you can't close your eyes to sexual assaults. You can't say that's a societal issue, they need to go to criminal court, or they need to bring a civil action. You have to deal with sexual assaults that take place that involve your students and your programs. So essentially, the DOE told colleges and universities, if you don't take the following steps, you run the risk of losing federal funds. Your students will not be able to obtain federal student loans. And for most colleges and universities, that would be devastating. So what did the Dear Colleague letter said had to happen? Well, they said you have to have a Title IX coordinator. You have to have someone who is accountable and responsible for making certain that Title IX is being enforced on your campus. It required mandatory reporting, and we'll talk in a few minutes about how extensive that is. But, essentially, if somebody in a responsible position on campus heard of a possible sexual assault, they had a duty to report that on up the line, and the university then had a duty to investigate that assault. That in and of itself was a sea change. There was a duty to investigate and to provide prompt and equitable resolution. So you had a 60-day period as a university in which to address any reports of a sexual assault. And that included having the hearing, having the appeal, all of that. And so you also had to have an equitable resolution. You had to have clear published grievance procedures. And that was something that frankly was missing. It's not that colleges and universities didn't have grievance procedures relating to sexual harassment and sexual assault, but it's funny that many of them weren't used frequently. So They didn't know how to use them. Oftentimes universities had multiple systems. Well, if it's an employee, here's the system that's used. If it's a student, here's the system that's used. There wasn't a lot of consistency. Complainants and respondents oftentimes struggled to know, well, where do I look to see the rules? So saying you have to have clear published grievance procedures was huge. I remember one of the pushes was, and we did this at the University of Dayton, you actually needed to have a link to a web page that described the Title IX process in detail. And we ultimately were able to get a link that appears on every page of the website. So the idea was to make it easier for people to report assaults. The DOE said, we don't want you to use a clear and convincing evidence standard, and we certainly don't want you to use a beyond a reasonable doubt standard. We want you to use a standard preponderance of the evidence standard. DOE said, we don't like direct cross-examination. We think that direct cross-examination by the other party, if you are a complainant, if you believe you were the victim of sexual assault, there's nothing more horrifying we can imagine than having the person that you are asserting assaulted you to cross-examine you. So cross-examination was discouraged. What was really interesting about the way this happened was there were no new regulations relating to Title IX. All of this was created with reliance on guidance. So they would put out letters and guidelines and suggestions and consent agreements that were entered into by universities and colleges that had been investigated by the DOE based on the idea that they had somehow violated Title IX. Not, in my mind, a great system, because it was really hard to know kind of what was expected of you. Whenever a new consent agreement came out with a university, every Title IX coordinator that I knew was trying to read it like tea leaves, because it oftentimes included, okay, the university now agrees this is going to be its grievance procedure. And you'd be reading it going, well, this procedure requires X, but I don't know if that is there because that school wanted it, or if it's there because the DOE said that that was essential. So, were there some really good things about this? Yes, and we're going to talk about those in a few minutes, but this was a sea change, and, this changed everything on campuses. It required a tremendous amount of resources, and it's a big obligation. Jordan, if you can go on to the next slide. So this was a daunting task. Under the initial guidance, colleges and universities now had a duty to investigate reports of any form of sexual discrimination, harassment that occurred on campus or as part of a university program. And it was sexual discrimination and harassment at every level, everything from a hostile environment. These students had this sign in the front yard, and I think that created a hostile environment, all the way up to non-consensual sexual penetration. So it was everything. It was employees, it was students, it was visitors. So if an employee felt that they had been discriminated against, that's going through the Title IX system. If somebody was visiting campus and they felt that they were assaulted by one of the students, that was part of the system. It was massive, the sheer number of cases. They also had a duty to investigate off-campus incidents involving 2 or more members of the university community. So a good example of that one is if you happen to have 2 students who were married, or for that matter, 2 faculty members, and there was an allegation of domestic violence, that had to go through the Title IX investigatory process. So what I want everybody to understand is there was just a huge number of cases, in every type of case that you could imagine. And a key thing to understand here is you had to investigate whether or not there was what you would call a formal complaint or not. The duty to investigate arose as soon as there was a report of something. So even if the report didn't come from the alleged victim, there was still a duty to investigate that. Jordan, can you move on to the next page? Initially, the DOE required that investigations, including hearings and any appeals, be completed within 60 days of the initial report. And again, I want you to understand how kind of constricting that was, because the initial report may have been to, say, a faculty member. If it took the faculty member a week to inform the Title IX coordinator, that week counted in the 60 days. It was not within 60 days of a formal complaint. It was within 60 days of a report to a mandatory reporter. So we had to do a lot of training with faculty and staff to make sure that they knew if they heard about this, they needed to report it immediately to the Title IX coordinator. We also worked really hard to create a report system, and this is something other colleges and universities did as well. We created an online form that people could use to report, to make it easy for people to report sexual assaults. But for those of you particularly out there who are attorneys, I want you to imagine conducting a sexual assault investigation and completing both the trial and the appeal in a 60-day period. Other issues with this. I want you to imagine conducting a sexual assault investigation and without subpoena power. And I think this was particularly difficult. Oftentimes parts of the assault or parts of the story in terms of what happened took place off campus, say at one of the local bars. The bartender may have seen the initial interaction or some of the interaction between the complainant and the respondent, but as the Title IX coordinator, you really couldn't compel them to participate. You could compel students to participate, but it was really hard to compel non-students to participate. I want you to imagine conducting a sexual assault investigation without expert testimony and without medical records. Again, oftentimes we had complainants who had gone to a hospital, had sought medical testing, but when you're talking about a 60-day period, it wasn't uncommon to have a situation where the testing hadn't even come back. Imagine conducting a sexual assault investigation while there was an ongoing criminal investigation. You really, as a Title IX coordinator, want to be careful not to step on any criminal investigation, but criminal investigations don't end in 60 days, and you're sitting there with the clock going tick, tick, tick. How do I do this? One of the things that's interesting is I want you to imagine conducting a sexual assault investigation, including a hearing, if you're not an attorney. With Title IX, and for that matter with campus discipline, there's a fair mix of attorneys these days, but you don't have to be an attorney to be a Title IX coordinator, and you don't have to be an attorney to run a campus judicial system. And this was really hard. I was always appreciative of the fact that I was an attorney because, frankly, as Title IX coordinator, that helped me understand so many issues and see so many potential pitfalls. But you are essentially saying, and again, I want you to go back to what we talked about with campus judicial systems. We're not a campus judicial system anymore. We're becoming more and more like a court. And, that is something to say to a college or a university, or as we said, a beauty school. You have to create something that's the equivalent of a court. Hundreds of schools faced investigation by the DOE's Office of Civil Rights. Because in this kind of a case, somebody is going to win and somebody's going to lose. And these are highly emotional cases. So whether you are a plaintiff or a complainant, or whether you were a respondent, if you lost, you kind of felt wronged. So they would complain to the Department of Ed, to the OCR. And as soon as they did, that could trigger an investigation. And on the final day of the Obama administration, there were 304 open investigations relating to sexual violence involving 223 colleges and universities. And when you were subject to an investigation from the Office of Civil Rights, they didn't just investigate this case, they would go back 3 years and look at everything you had done with Title IX for the past 3 years. They also would say, okay, if you want to settle this, you can, if we find that there's something that we think potentially would be wrong, you can have a consent agreement. You can essentially settle. And, here's how we want you to change what you're doing at the university. So, it may be revamping your grievance procedure or adding more educational opportunities. It was a huge, huge task, and there is no campus official that I know who didn't blanch at the thought of this investigation and all of the time and the effort that it was going to involve. So, and you had 60 days to do your investigation, but I know in latter years, if you were being investigated, you could plan on kind of a 2 or a 3-year investigation of your university. Okay, Jordan, can you go to the next page? Okay, all of that being said, what was good and what was bad that I think came out of the Dear Colleague letter? And again, these are my opinions, not necessarily those of the university. To me, the big thing was victims were heard. A student cannot learn if he or she is forced to sit in class next to the person who sexually assaulted that person. And before, frankly, there was as I said, it wasn't that schools had no compassion, but I think it was such a huge issue. How can we investigate these? That, there were cases that could have been investigated and probably should have been investigated that weren't. What else came out of it that was good? Oh, schools became so proactive, so much more education. So many universities brought in people to provide training and assistance in preventing sexual assault. UD had started something called a Green Dot program, which is where, peers are trying to prevent sexual assaults. That was a very, very good thing. The processes really were improved because I think campuses and universities had to sit down and come up with something clear. They had to advertise it. I think people who had suffered sexual assaults actually had somewhere to turn. So there was a heck of a lot that came out of this that was good. There is a problem with non-consensual sex on campuses, and this said, look, you have to open your eyes, you have to deal with it. Okay, the bad. I think there are unreasonable expectations all the way around. I think we've created the expectation among students that universities can kind of fix issues that go well beyond our ability to fix. I worked with complainants who said, well, I don't want to go to criminal court because I think that would be really hard, but I think I can be heard here. And that was a really good thing. But again, universities lack the power of the courts. And so I think that there were kind of unreasonable expectations about how much we could do to deal with an incident of sexual assault. I think universities may have made a gallant effort, and I applaud them. They really have tried to set up systems that work. But again, how can a university, even if it's willing to pour in the resources, really create a judicial system? Another bad was the overwhelming caseload, because since every report had to be investigated, you really couldn't separate out the wheat from the chaff. You had to investigate everything. Frankly, even if there was no complainant, there was just a reporter. And I think that has lessened the ability of schools to focus on the cases that are truly serious cases. And the other thing was the OCR investigations and civil lawsuits by students. When you are a university and you are trying to create a judicial system, again, try though you might, no matter what you do, you're going to be open to criticism. And that criticism turns into investigations and civil lawsuits. Jordan, can you move to the next page, please? So when the Trump administration came in, it had a very, very different view on what colleges should be doing. And, there had been a lot of criticism and a lot of pushback over the years from respondents in cases. They often felt that they were not getting a fair deal. Now, again, I think part of this goes to the idea that they wanted the same rights that they would have in a criminal trial. And a campus judicial proceeding is not a criminal trial. You're not facing jail. To be honest, in most campuses, most colleges, it doesn't even go on your disciplinary record. So if you are expelled from school one based on being involved in a sexual assault, you can apply to school two the next day, and there's a good chance it won't know that. So you don't have the same ramifications. And as I said, I think something that people need to understand is the standards are fundamentally different. There are behaviors that you want to prohibit on a campus in terms of sexual behavior that just don't reach the level of something that has been made a crime by society. So there had been a lot of pushback on this. And Trump administration came in the door saying, we are going to change some things. And in August 2020, it finalized its process. So it substantially changes the rules and the process through the regulatory process. It limits responsibility for off-campus incidents. Most off-campus incidents now are not under the jurisdiction of the university. Now, with all of these guidelines, the university is permitted to prohibit more than Title IX and to try to extend its jurisdiction. It can do that under its own processes, but it's not required to address off-campus incidents. So, if you had a situation where a student was living in an off-campus apartment and another student allegedly sexually assaulted that student, now there would be no duty to investigate that. It eliminates mandatory reporting. Again, campuses and colleges and universities can still seek to require or can still require its employees to report, but they don't have to now. So, you know, a university can say to its coaches, for example, you know, you're going to be a confidential resource, someone that your students can talk to, and you will not have a duty to report everything that they say. Prompt resolution is still required, but the 60-day guideline timeline is gone. It can take much longer now. They actually created very specific technical requirements for the investigation and the hearing. For example, a decision maker now has to apply rape shield laws. They said preponderance of the evidence standard is not a requirement. Campus has to use preponderance of the evidence standard or a clear and convincing evidence standard, whatever it's using for cases involving claims of harassment against employees has to be used for students. A big change is it now requires live hearing and direct cross-examination. The direct cross-examination we'll talk about in a minute, but that is a sea change. That is something that was discouraged under the old rules. And there is now a presumption of innocence, or schools can at least create a presumption of innocence, which in the past did not happen because, again, this isn't a criminal proceeding. This isn't deciding, do you go to jail? The basic question is, you know, as a student, should you be punished? Should we do something to rehabilitate you? Or if we're talking about a sexual assault, should you be suspended or expelled? Jordan, could you go to the next page? I want to talk a little bit about the good and, oops, oh, I think you went back. There we go. Let's talk about the major changes. And you can move to the first change. Okay, the mandatory reporter requirement. Under the Obama rules, action by school was triggered if a responsible employee knew or should have known of sexual violence. Responsible employees could include faculty, coaches, residence assistants, and a raft of other people. And it's interesting because it's not even, there wasn't an actual knowledge requirement. It's knew or should have known. So it's a negligence standard in terms of the reporting. And as soon as any responsible employee knew or should have known of sexual violence, again, that 60-day clock started to run. Under the Trump rules, action is required only if a school official with the power to take corrective action has actual knowledge of sexual violence. Under this rule, the school, as we discussed, can opt to exclude faculty and coaches and all that from the list of mandatory reporters. It's only if a school official with the power to take corrective action learns of something that any action is required, and they have to have actual knowledge. Jordan, could you move to the next page? Under the Obama rules, an investigation was triggered if a responsible employee knew or should have known of sexual violence. In other words, every single incident that was reported had to be investigated. Under the Trump rules, supportive measures must be provided to the complainant if a school official with the power to take corrective action has actual knowledge of sexual violence. So the action that's triggered automatically if there is a report of to the proper official of sexual violence is there's outreach, there's supportive measures, there's getting the person counseling, wide range of things that we can do to support students. But an investigation is only triggered if either the complainant or the Title IX coordinator signs a formal complaint. So, you know, that is far more limited. There are going to be fewer cases that Title IX coordinators and college judicial systems are dealing with, because there has to be that formal complaint. The other interesting twist on this is a complainant must be participating in or attempting to participate in the education program or activity of the school. So this kind of leaves the question of whether visitors are still protected under Title IX in question. If you look at the plain language, it would seem that universities are not required to provide Title IX protection to visitors. The other thing is, there essentially is no statute of limitations on Title IX. So we had students, former students, alums, kind of report things 5, 10, even 20 years after they happened, and that triggered and had previously triggered an investigation. My reading of this rule is it will no longer trigger an investigation. It's, you know, only if you are still connected with the program that you can seek the protection of Title IX. Jordan? Under the Obama rules, live testimony was optional and direct cross-examination was discouraged. Both parties were permitted to have attorneys, but there was no requirement that the attorneys be permitted to actively participate in any hearing. In other words, students were allowed to have an attorney sitting next to them during a hearing, but they were there to advise the student, not to conduct any sort of examination of the witnesses. And that was kind of an interesting rule when the Obama administration said, you know, you must allow attorneys to participate. Many schools had rules that actually didn't want attorneys in the advisor role. When that came into play, it was, I know that it was honestly intended to help complainants, but the bottom line is, because respondents may be facing criminal liability as well, they're far more likely to have an attorney. So I saw a lot of kind of imbalance where you had a respondent sitting there with an attorney and a complainant sitting there with a mom or a roommate or a friend. So, you know, bringing attorneys in is an interesting point. Under the Trump rules, live testimony is required. No statement may be considered unless there's cross-examination. And cross-examination of parties and witnesses may be undertaken by advisors who may be attorneys. So this is going to change everything. Under the old system, I think most schools had something where the parties could suggest questions, could say that, you know, we would like to ask this, but they were funneled through and asked by the decision maker. Now the parties can't question each other, but the party's attorney can cross-examine. And again, I could foresee a situation where you have an awful lot of respondents who have attorneys and an awful lot of complainants who don't, which makes another of the new rules interesting, because if either party lacks an advisor, the school must appoint one. And to me, what gets interesting with that is, in terms of the liability of the school, if I know that the defendant, or the respondent, is being represented by counsel, I would feel very weird giving the complainant an advisor who isn't an attorney. I just see that as opening schools up to the potential for liability. And, you know, how do you pay for attorneys for all of these? Again, schools have a resource issue. This applies to beauty colleges, not just the Ohio States of the world. Okay, next page, Jordan. Clear and convincing evidence standard, again, is a change. Under the Obama rules, the evidentiary standard that must be used is preponderance of the evidence. It has to be 50% plus a feather in terms of the finding. And under the Trump rules, a school may choose between using preponderance of the evidence and a clear and convincing evidence standard. Okay, next slide. Okay, so let's talk about what the DOE got right and what it got wrong in terms of the most recent changes. The good. I think having clear regulations is a good thing. It is not something that the Trump administration is necessarily known for. It's actually been deregulating, but it actually went through the full regulatory process, and it did hear from all sides, and it did change some of the proposed regulations. So, I think it's a lot better to have regulations, frankly, than to have to look at a consent agreement from another school and wonder, okay, what applies to us? I think the focus on supportive measures is great because that's what campuses are really good at. I think that's a strength and always has been. So I think saying that that's the expectation is great. I think limiting responsibility for off-campus incidents is great because it really is next to impossible to conduct a full investigation of something that happened off campus. It's just incredibly difficult. I like the requirement of a formal complaint before you move forward because again, would get reports from all kinds of people, and I think that requiring a formal complaint is going to limit the number of cases that the Title IX coordinator is dealing with, and I think that will allow that person to do a more effective job with those. The bad, even more unreasonable expectations. The idea that universities are going to be able to appoint advisors who measure up against counsel. I think it's a slippery slope on that. The hearings and the investigative procedures have become even more formal than they were, and it's not a trial. It's a university, it's an educational institution, and it is just so much to ask to have enough decision makers who are trained to handle, even with the more limited number of cases. I think it's a lot to ask them to handle that. The presumption of innocence. I want to go back with all of this to what schools are good at doing, what they are able to do. We are really, when we are looking at student claims, at most what we're looking at is, do we want to continue to allow this person to be a member of the campus community? It is not a criminal case. And I think that, creating the presumption of innocence, and again, schools don't have to do that, but they're going to be allowed to do that, totally changes the dynamic of what's happening when you're trying to do the investigation. And that's my bottom line with all of this. I think that Title IX has done a lot of good, but I would love to see us become a little bit more realistic about what it is that a campus can and cannot do reasonably in the way of investigating this type of wrong. Jillian, I think you're up.
Okay, thank you, Dean Shaw, for your thoughts. And good afternoon, everyone. This is the first time I've popped up on your screen.
You're muted,
today.
Jillian.
Am I? It appears that I am unmuted on my end. Can others aside from Dean Shaw hear me?
Oh, I think you're still muted.
I can hear you, Jillian.
Okay. Jordan, you can hear me. Attendees, if you can throw in the chat if you can hear me. Okay. It looks like I can be heard. Dean Shaw, perhaps you're having trouble hearing me, so
Oh,
that might
maybe
be
it's me.
something. There you go.
No, my
Okay.
system. There we go, Jillian. Sorry about that.
No worries, no worries. So good afternoon to everyone. I hope everybody is doing well again. Thank you all for having me. I always feel incredibly honored to be among the minds that are participating in this conversation today. As has been mentioned earlier, we are talking about the foremost scholars and foremost thought leaders as it relates to education law and education policy and its formation. I think Dean Shaw did an incredible job sort of outlining the history behind Title IX, the old rule, or I'm sorry, the old guidance under the Dear Colleague letter out of the Obama administration, and then of course the pros and the cons from the new rule that is now effective and in operation today. And just some things that I wanted to point out, some points that Dean Shaw made that I'd like to reemphasize. What's interesting about this new Title IX rule, it includes additional layers of process. It creates this system that looks very much like the judicial system in terms of what may result in almost a full court proceeding, related to behavior that happens on campus. But I think at the heart of this new rule is the presumption or the belief that participation in education is valuable. And before that participation can be taken away, there has to be these layers of process afforded to, in this situation, the respondent before that can be taken from them. And I think generally that generally is a good thing. It's a good value to have, certainly. Some notable differences that hopefully Dean Shaw didn't mention. If she did, I may have missed it. Between the new rule and the old, one that particularly, I found to be very interesting is that included under the new rule, their stalking, domestic violence, and dating violence are officially considered examples of sexual harassment under Title IX. And I think that's a very important inclusion. I think it's a very well thought conclusion. Dean Shaw mentioned this administration went through the process of creating these regulations. The notice and comment period was extremely lengthy. I believe I read that the Department of Education reviewed something like 124,000 submitted comments. And those comments came from all different perspectives, all different institutions, all different schools of thought. And the department was very mindful of those comments and did in fact revise the rule that they had originally proposed in response to some of those things that were sort of communicated to them, which is great. The other thing that the new rule does, again in the broader sense, is it defers to colleges and universities to make decisions where appropriate that best fit the students that they serve. So, effectually giving colleges and universities some discretion about what standard to use, for instance, preponderance of the evidence, clear and convincing. It gives that institution the opportunity to discuss those standards, to perhaps educate policymakers on the difference between those standards, because mind you, people in universities who are creating policy may not always be lawyers, and may not have a deep understanding of the difference between the preponderance of the evidence standard and clear and convincing standard. And so it leaves room for universities to have that discussion, to become educated in those differences, those substantive differences, and to be able to make a decision that is best for them and best for their students and their faculty. The new rule also, as Dean Shaw mentioned, and I think is important to highlight, is the ability for universities to provide support that may manifest in a number of different creative solutions. And so it gives universities the abilities to come alongside someone with a complaint to say, very practically, do we need to move your dorm? Do you need a different class schedule? Do you need other types of accommodations that may, serve to resolve this issue? And I think that flexibility that wasn't there before is extremely beneficial, and oftentimes works better for a complaining party who perhaps is not comfortable with the idea of an investigation. And that's the other thing that ties to is the new rules tied to when an investigation is required. And as Dean Shaw mentioned, in order for a full investigation to take place, you've got to have a signed complaint. And part of that, I think, accurately presumes that then the complainant is willing to participate. Whereas prior to, under the old guidance, universities were required to investigate an issue where perhaps the parties may not be willing to participate or may not want to participate. And without the ability to compel, as was mentioned, made for some very difficult, very cumbersome, burdensome caseloads. In a prior life, prior to my education law practice at a firm, I served as general counsel to the Dayton Public School District, which at the time served 13,000, 14,000 students, K-12. And I also served as the Title IX coordinator in that space. And so hearing Dean Shaw's sort of account serving as the Title IX coordinator in a university setting versus my experience as the Title IX coordinator in the K-12 setting and under the old guidance, a trained eye sees this new rule as probably some well-received clarity for those that are administering the Title IX process in the educational space. Because I think without it, before, there were advisors to school districts, to colleges and universities that maybe wouldn't have some clear answers on how best to protect educational institutions from liability when handling these types of cases. And that can be a very tricky thing to navigate. So, I think generally the new rule, as Dean Shaw said, good and bad points, beneficial and cumbersome points. And I would encourage, those of you that have joined us today, I would encourage you to spend some time, and there are lots of resources available, reading through what is like a side-by-side of the Title IX regulations prior to the new rule being implemented and the new Title IX regulations. Now they're implemented, it's very easy to see where the differences in language exist. And I would encourage you to review documents like that, because I think as it relates to Title IX in general, headlines, at least our modern day headlines, can be a little misleading as to what this new rule actually means for young people, what the rule actually means for colleges and universities, what it actually means for folks who work in those spaces. So, again, if there are questions about the nitty-gritty piece of what is considered this, what is considered that, we will see as this new rule, I think, became effective. I think it was August 14th, so just over a month ago. And, be very interesting to see how it is received by, those young people who participate in this process under the new rule, as well as those education professionals who participate in this process under the new rule. So those are sort of my general thoughts on this particular matter. I don't know, Dean Shaw, if you had additional comments to make on that, or Jordan, if we have any questions from our attendees about this new rule in general.
Yes, yeah, if you don't have any additional comments, Dean Shaw, we do have a few questions. I guess, first of all, Dean Shaw, somebody asked about how, when you talked about actual knowledge, how that's defined. Is it evidence, a third-party witness? Because a lot of it's one person's word against someone else's. Is that complaint count as actual knowledge?
Yeah, it's really just notice to the Title IX coordinator or whoever has been appointed. So that's what starts kind of the whole process. But again, even with that, all that is going to require is that outreach, kind of the supportive measures, unless and until you have an actual signed complaint, you're not going to go beyond that.
Another question, how about like fraternity or sorority houses? Do they count as on campus, off campus? Where does that fall?
That's a really good question. That's actually one of the things, and as Jillian mentioned, that I applaud the fact that there was a long notice and comment period on this, because that was something that was raised, and there's a specific exception for fraternities and sororities. They tie them in with the program because they are tied to the university. So they did create an exception for sororities and fraternities, but not necessarily for any other housing that's off campus. And if you look around UD in the student neighborhood, there's most of the houses in the student neighborhood are owned by the university, but there's still landlord-owned houses there. Now, again, Title IX, or the new rules don't say that the university is prohibited from involving somebody who would be engaged in a sexual assault there in the disciplinary process. It's just it doesn't fall under the Title IX jurisdiction, so they don't have to do that.
And something else that a question that maybe you both could answer. What about the conflict, or is there a conflict between prompt and equitable when you talk about those terms?
Let me take that, Dean Shaw. Sure. So I wouldn't view them as conflicting, because often, in order for things to be equitable, the previous restriction, 60-day restriction, may have impeded upon the ability for an organization to administer this process in an equitable way. So I think, under this new rule, by using the term prompt or reasonably prompt, it allows for the full process to unfold, because oftentimes these scenarios that arise are so fact specific. They may have multiple witnesses, multiple folks that have to be investigated, and those sort of things, in order to be done well, take time. So, in at least in my experience, prompt is a flexible term, but you wouldn't want to sacrifice the equitable nature of the process in order to serve quickness, I guess, for lack of a better word. So, I don't foresee them as I don't see them as conflicting concepts, and I think it's best that folks, let time pass in order for equity to exist.
The one point that gets a little bit sticky is under the old rules, let's say that you had two students who were, living right next to each other. Under the old rules, you were allowed to move the respondent. Even though the respondent had not yet been found responsible, you could move them across campus so that they don't cross paths. Because in all honesty, as a Title IX coordinator, it never bodes well when the parties cross paths. It just, bad things happen. You get retaliation claims and you get all sorts of things going on. So, now you're not permitted to do that. You're not permitted because in essence, you would be punishing the person before they were found responsible. But that makes it a little bit tricky because, there may be reasons why, if the complainant is particularly emotionally fragile, you may not want to move the complainant either. So, I think that, and that goes when we talk about the prompt and the equitable piece. The longer this process is, the more chance there is for those encounters. Campuses are not that big, and you've got the parties and you've got their friends, and everybody is highly emotional. So I think that's something that is going to create some issues.
I know Mr. Throw wanted to had some comments or questions. It's going to bring him in here real quick as well.
Sure. Thanks. And thanks to both Lori and Jillian for giving us a great overview of the new regulations. I found their presentation fascinating because it's the first time that I've seen and heard a presentation from the perspective of what this means for a private institution. For those of us at public institutions, we have this added wrinkle of we're subject to the Due Process Clause. And the Sixth Circuit has unequivocally held that a lengthy suspension, a year or something, as well as expulsion, requires due process before it happens. And in response to a number of Title IX cases involving University of Cincinnati, Miami University in Oxford, as well as the University of Michigan, the Sixth Circuit has effectively adopted, prior to the regulations, what is now the regulations. For example, in University of Michigan, or Baum versus University of Michigan, the Sixth Circuit said that not only was there a right to cross-examination, but that cross-examination must take place through the either the attorney or the actual student, which has caused the University of Kentucky, which previously did cross-examination through our hearing officers, to change things. So it's a burden for the private institutions, but public institutions have had to do this. And even if the regulations go away, should Vice President Obama win, or Vice President Biden win the election, those of us in the Sixth Circuit are still going to have to abide. The other thing, and this is a bit of a dissent with Lori, she was like, "Oh, this is no big deal. This is not a criminal matter." Well, as I suggested, the Sixth Circuit seems to take a different view, at least with respect to expulsion. But I think for the public institutions, potentially, if you're going to throw somebody out, it really is a big deal, and is perhaps somewhat analogous to a jail sentence. And just to give a couple of examples, in two states, Michigan and not Michigan, New York and Virginia, if you are expelled for sexual assault, that fact is noted on your academic transcript. Okay, so it's not something that you can hide. In addition, in the Southeastern Conference, and I think also now in the Atlantic Coast and Big Ten, if you are an athlete and you are found guilty of sexual assault, you are probably kicked off your team, but you are ineligible to transfer to another school. So, we've had at the University of Kentucky instances where a football player has been accused of sexual assault, and so he's looking at 4 years of tuition, room and board, all the great coaching, all of the academic support. But if he's found responsible, his career at UK is over, and he can't transfer to any of our rivals. Now, this is not to say, given the stakes, that we shouldn't take this seriously. We should, and I think the support mechanisms are absolutely fantastic. And quite frankly, if somebody engages in sexual assault, they should be removed from our community. But I think it's enormously important that before we do this, before we remove them from the community, that we make sure that we reach the right result. We see all the time in the criminal justice system where people have access to paid counsel and where people have, beyond a reasonable doubt, unanimous juries. We see all the time people who have been in jail for 10, 20, 30 years suddenly being released because DNA evidence says that they're innocent. Well, imagine a situation where we're going to decide on 50.01% that somebody is guilty and potentially change that person's life. And I think this is one reason why the Sixth Circuit has been so adamant on due process considerations. But it's a fascinating area of the law that will continue to develop. Thanks for allowing me to chime in for a minute.
Oh, and Bill, I've got a couple questions for you, because is sexual assault being treated differently than, a student who's, violating drug laws, a student let's say you had a football player or a basketball player who beat somebody else to a pulp. Is it being treated the same? I guess that's my first question. And I think my second question is, do you think and see, this is one of my things, as I said earlier, I think people don't understand that we're not using the same standard for sexual assault that they would see in a criminal case. So do you think that if it's going to be treated as sexual assault in that sense, should we be using the same standards that the criminal law uses?
Let me answer your first question, and then let me make sure I understand the second question. As we read the Sixth Circuit's decisions, any case in which the student is facing expulsion or a lengthy suspension, those due process rationales are going to kick in. So if we're going to kick a kid out for drugs, if we're going to kick a kid out for beating up one of his peers, then they're going to have the right to cross-examination, and they're going to have the same due process rights that would apply in a Title IX instance like that. I'm not sure that I understand your question regarding the difference in the definition of sexual.
I think because you were talking about like the reputational damage and all of that, and I think most people don't understand that. I think most people don't understand how very different the standards for consent and a world of other things are on the college level. So it's entirely possible for a university to say, to find this student violated our rules, and have a fair hearing and find that. And that's something that's always troubled me, because I think, you don't want the public to perceive that as this person, if they had been tried criminally, would have been found guilty of rape, because they're honestly two very different standards.
They are different standards. And, the example that I sometimes use with some of our administrators is, okay, Johnny and Susie end up having a sexual encounter. One of them says that the sex was non-consensual. The other one says, yes, we had sex, but it was consensual. Okay. Who knows what the truth is? And truthfully, both of those young people sincerely believe their version. They could probably pass polygraph test. Okay. If one of them goes down to the local prosecutor and presents those facts, nothing is going to happen. And the reason is, even if the prosecutor believes that the victim survivor, the prosecutor knows very well that she cannot get 12 people to unanimously agree beyond a reasonable doubt that a crime occurred. So in effect, the jury unanimity and the beyond the reasonable doubt prevents there from being a criminal prosecution. Okay. However, in the Title IX context, 50.01%. Okay. If I believe X, then Y is guilty. That's essentially what it comes down to. And that is a very different standard, but also has some significant ramifications. I mentioned the transcript, I mentioned the athletics, but you're a law school dean. I guarantee you ask every single applicant, have you ever been subjected to student discipline? If so, explain. And well, my buddies and I had beer and we weren't supposed to. We don't care about that. Well, I was accused of rape when I was a sophomore and found guilty and kicked out of school for a year, but I want you to know that I didn't do it. Okay. How are you going to react to that? And, how is the bar or the Army or the CIA going to react to a security clearance for something like that? And, don't misunderstand me. If the person did it, being removed from your community is absolutely the appropriate punishment. But human beings make mistakes. And, I think what the Sixth Circuit is saying is we need to be a little bit more sure on this.
All right. I think it's time for a break. If people want to take a break, I mean, we could I have some more questions. Would you guys want to stay on and answer? Would you want to wait for the panel discussion to answer? Oh, I think I can't hear you, Lori. Could you?
Yeah, let's wait for the panel discussion. That's
okay. So I know some of you had some questions we didn't get to. We'll try to get those in for the panel discussion. So we'll take a 10-minute break. And we'll be back at 2 for the last session. So we'll see everybody then. Start recording. We are. And we'll go ahead with the final session and make sure everybody gets out of here at 2:45 so you can go enjoy your weekend. Beautiful day outside here in Dayton, at least. So we wanted to kind of pick up just at first with some more people had some questions about some of the Title IX issues. A couple interesting questions. One that jumped out. What about with virtual learning? What kind of happens with it if there are any kind of Title IX complaints where there's not as much in-person contact between students and professors.
I think that still creates the issue of, if you had a situation where a faculty member was accused of assaulting a student, I think you still have a student saying, I can't learn from this person. I think that's, even though there's physical distance, I think it's the psychological side of it that's going to be problematic, and particularly problematic if it's the middle of the semester and that's the only person offering that course and the student needs that course to graduate. It gets messy.
And somebody brought up that point as well. I mean, what do you do if it's a small situation? Like you said, that it's a department. There's maybe only a professor or two. What kind of happens there? I mean, if that student can't take those classes, or how was that handled?
And I mean, that is one where you have to get creative. I mean, sometimes you'll do independent studies, or, you might arrange for the student to take the course from another university. I mean, there are no quick and easy answers on that.
A couple other real quick we'll get to. Some people wondered about kind of reporting and numbers about our reported instances of Title IX violation versus found instances. Are those reported to students?
No, those aren't.
And then are there any kind of numbers out there on how many students have been dismissed, I guess, across the country or within individual universities or states for Title IX cases?
Not really, and because part of it, and as Bill said, I mean, it's interesting, there are just a couple of states where there were even records of that on transcripts. And a lot of schools have a policy of essentially destroying transcripts or destroying like disciplinary records after X number of years. And we have, because Bill mentioned law students and the character and fitness piece, and it gets interesting because I've had some students who assumed, oh, if my university is destroyed the record of this, I don't have to report it. And that's not a good assumption to make. The bar has a way of finding things out, but that's it's a tough issue because we don't have stats. And it's not even just colleges and universities. There are just lots of small institutions that beauty colleges or all sorts of vocational things where students are able to get student loans, so Title IX applies. And those aren't, I don't think, being watched with the same care as a big university, but the rules are out there.
Yeah, some people want to know about UD's numbers on it. I mean, does that even exist?
I don't, it is, I never released them, and I don't believe that those have ever been released. Clery Act is crimes on campus, but not Title IX.
And then
I don't mean to intrude on this.
Sure, you can go ahead.
I don't want to intrude on the discussion, but some of this crosses the line into social sciences research. And if somebody's looking for data like that, the one person I would Google and look up, she used to be at Hofstra, I think she's at Virginia Commonwealth, is Charol Shakeshaft, Charol Shakeshaft. She worked 20, 25 years ago with the Department of Education on a number of the documents and advisories. And I know she's still very active in that area. So for people who want some of that kind of softer data, as opposed to litigation, there's a pretty good body of literature growing around the work that she's done and people in related areas.
Yeah, and I also think it's important to recognize that while Dayton can decline to release the information, public institutions generally cannot because of state open records acts. Now, obviously, FERPA applies, so we're not going to be able to tell you what happened between Johnny and Susie, but we would be able to tell you that, we had 20 odd cases, and 5 of those, 10 of those went to hearing, and that, there was a certain level of outcome with those, assuming we get sufficient numbers. And that results in a good degree of fighting as well. We have a case at the Kentucky Supreme Court right now where a faculty member sexually assaulted some of his graduate students, and the student newspaper wants not the record of the outcome, but the records of the investigation. We've declined on various privacy grounds, but it has been in some respects all-consuming.
Yeah, and another point, Jordan, to a question that was answered earlier, or that was asked earlier about this idea of prompt and equitable, that sort of relates to our discussion. There have been instances where you've got a student who has been accused of misconduct at a university, who sees where this issue is going, who foresees this pipeline of investigation, interviews, this quasi, adjudication type process, and before it is resolved, will withdraw and re-enroll elsewhere before any of this information either appears on a transcript or in a record of any kind. So, while the system is not perfect, these type of offenses can follow young people, but often, or it's possible that it trails many months afterwards.
Mm-hmm. And I guess it's kind of, somebody asked about whether there's anything on some schools finding no fault more than others, but I guess without stats, I mean, it'd be hard to really know.
And different schools have defined the offenses in different ways, and that makes a huge difference in outcome.
Right.
All right.
As well as the willingness of the complainant to go forward. One of the things that is really great about the new regulations is it does say you'll give support mechanisms, regardless of whether the victim wants to go forward. But I mean, a lot of schools, it's like, okay, as long as the other person stays away from me, we get my classes changed, I'm fine. I don't need to go through the hearing. So consequently, something that could result in an expulsion does not. And that's, you can't really find somebody guilty if the victim is not willing for whatever reason to cooperate.
And then the other question, somebody just asked before we move on to some of the other cases and things, about whether the University of Dayton pays for an attorney for Title IX cases. I'm not sure, Dean Shaw, if you know of that or how that process works.
I mean, when I was involved, we didn't. I think, that's where I'm curious in terms of, because this has just been in effect for a month. I am curious as to how schools are going to deal with the idea that you have to appoint the advisor if someone does not have one. Because as I said earlier, I would feel utsy about that if I'm saying this person is good and they're not an attorney and they're up against somebody who is an attorney. I don't know where schools are going to take that. I mean, my inclination, I am assuming, by the way, that the respondent will have an attorney sitting next to the respondent, just because that was what I saw 99% of the time. But that is going to be, we'll see. It's going to be, if they do, it's going to be a huge expense for universities. And again, you get into this whole idea of, how much responsibility does the university have for this? So, I think that'll be an interesting thing to watch.
Yeah, an added wrinkle on that. In Kentucky, it's an open question as to whether a non-lawyer can be an advisor. Obviously, if it comes back that you have to be a lawyer, then the obligation to give an advisor means we have an obligation to provide an attorney and to pay for that attorney. So, and this is the process, whether we use the regulations or what the Sixth Circuit has said, is extraordinarily expensive and really puts the universities in effectively running a parallel criminal justice system, something that they're not really good at, something that they're not, are as great as I'm sure Lori and Jillian were at their jobs as Title IX coordinators. Unless I'm missing something, neither of them is trained as a police investigator.
Well, and getting to the point we talked about earlier, and Jillian mentioned it as well, the idea that, non-attorneys understanding basic terms. I went to the Association of Title IX Administrators, the ATIXA training, when I started as a Title IX coordinator, and it was in 2012 when everybody was scrambling to do that. And I was sitting at the conference or at the training next to a woman who was the chancellor at her university, and somebody just said, "Oh, we'll make you the Title IX coordinator." A very bright woman, very nice, but she was sitting next to me, and I remember they were going through at one point the difference between, preponderance of the evidence and beyond a reasonable doubt or something. And I was actually taking the opportunity to check my emails because I'm like, well, yeah, I got this. And they talked about it for what seemed like forever. And then they had a break, and this woman looked up at me and goes, "Lori, what did they just say? I had no idea." And I thought, oh, this is what you're asking people to do. The one other point I was going to make, going back to what Bill was talking about, I mean, there would be, if I were a respondent, and I know that they're going to be appointing an attorney for the complainant, I'm not going to hire my own. I'm going to say, university, you pay for my attorney too. So, I mean, I think it gets interesting.
All right. Well, oh yeah, Bill.
In another wrinkle, we keep assuming that this is Johnny versus Susie, with Johnny and Susie having their own attorneys, but it's not. The burden of proving that the respondent actually violated policy rests on the university. So we in effect have the university with their attorney, Johnny with his attorney, Susie with her attorney, all of which will be paid for by the university, by the way.
Plus, the decision maker, the person running the hearing, should be an attorney at that point.
Yeah, we have tended to use retired judges merely because they're good at this and can keep attorneys in line. But yes. All
right. I know, Charlie, you had something you wanted to bring up, a case from New England related to religious religion and education.
Let me unmute. I don't want to take this away from Title IX, but I mentioned earlier there was one case I was aware of. For anybody who's interested, it's called Carson v. Macon, M-A-K-I-N, 401 Fed Sup 3rd, 207, Maine. I think it may well be covered by the cases we've been talking about, Espinoza. But the law in Maine is that if a district does not operate its own secondary school, the school districts or school boards, school committees will pay tuition for children to attend non-public schools. However, the court ruled that parental chosen non-public schools can only be non-sectarian. And the judge wrote in his opinion, and I quote now, "This is destined to go to the First Circuit on appeal and maybe the Supreme Court." Now, again, being able to distinguish cases as people who are trained in law, we could probably argue both ways, that it may be covered by Espinoza, may not be covered. My point simply is that litigation on school choice is not going away. There will be issues continuing to come up, and there might be a case worth looking. I did check Westlaw just a few minutes ago, and an appeal is still docketed. It has not been taken out, so just wait and see what happens. Thanks, Jordan.
Yeah, no problem. Any thoughts on that from the other panelists that you wanted to add, or? Oh, oh, I think you're muted. So there.
I'm not familiar with the case other than what Charlie just said, but it occurs to me that based on what Charlie said, Maine is giving some benefits to sectarian private school or to secular private schools, but not to the religious schools. So if Charlie's operating a Catholic high school and I'm operating a secular high school, and they're both private, I can participate in the program and Charlie can't. And framed that way, that seems to be an easy out under Espinoza. It's interesting that it was still docketed. I suspect the First Circuit may have been waiting for Espinoza before moving toward resolution on that. So we'll see.
Charlie, I think you're muted.
You're muted. Charlie, turn on your microphone.
Sorry. As Bill was speaking, I just pulled it up and it's still up there on Westlaw. No decision has been made. So it's still apparently active. And I agree with you that it may well come under there, Bill.
Yeah.
But it's not there until it's there.
What's the year, Charlie? When it
2019.
Okay.
And I'm surprised it's taken that long to get some additional resolution of it. But
Well, they may have been waiting for Espinoza. We also have COVID, and quite frankly, the First Circuit is not the world's fastest circuit either.
yeah, we'll see. Checks in the
All
mail.
right. All right, we've got a couple other questions. And again, submit your questions with the Q&A feature, and we can get those to the panelists. Mr. Throw, this one's for you. How much money have state universities like UK paid in attorney fees in cases that have been overturned? I don't know if you'd have an exact amount, but I don't know if you're able to speak to that a little bit.
I'm not quite sure of what the question is.
I think it might have been related to Title IX investigations.
Yeah. Well, the University of Kentucky, no, because we have managed to comply with the Constitution and also with Title IX. Some of the other institutions, quite a bit. But even when you win, litigating something, taking it to the Sixth Circuit, potentially taking it to the U.S. Supreme Court, is an expensive proposition, and we spend a great deal of money on the whole Title IX process in terms of training our decision makers, the retired judges that we have running the hearings. As well as our entire Title IX office, which when Lori was the Title IX coordinator at Dayton, basically didn't exist at the University of Kentucky, and now has, I think 5 or 6 people.
I think if I could chime in, Jordan, I think it's a really good question to ask, just to be generally aware of the public institutions, perhaps in your geographic region. At Dayton Public, a K-12 urban education system that traditionally does not do well academically, if they employ an in-house attorney, there may be one who manages the work of other attorneys who are defending the school district against certain claims that are made in various areas of law. So to simply ask the question about how public institutions spend funds to defend themselves against certain claims is a really pertinent question to ask. As it relates to these new Title IX regulations, I suppose we can maybe add that to the balancing of our opinions on its contents. It is a more expensive process but arguably is a process that is more efficient for truth finding. And so, is one more important than the other? I don't know. But a question that public institutions often have to ask themselves is, do we move forward with this piece of litigation, or do we settle in a way that perhaps might be more cost efficient? And that's a really tough question to discuss, especially if we're talking about something that might create an interesting or new or important rule of law versus what may be the responsible spending of public dollars. So there's just a lot to consider and a lot to unpack within that question. Not sure that the asker intended to unpack all that, but I think it's important to pose.
Another question we could get to. I don't know how much it has to do with what was exactly talked about, but somebody wanted to know about a Northeastern Zoom town hall. It said a number of professors stated they were racist as part of their introduction at the beginning of the town hall event. Does this constitute an issue? I guess related to an issue of, I don't know, of education of the students who might be upset and wouldn't want those professors, or anybody be able to field that?
I'm not sure I understand what the question's wanting to ask, to be honest with you.
Okay, yeah, if somebody wanted to know, if you're able to type in and clarify that, just let us know and we can try to help that. We'll try to get to some more questions in the meantime. Somebody types in, I think it's the Macon case had supplemental authority that was filed in the end of June after the Espinoza case was decided in terms of Title IX or equal access. Somebody wanted to point out.
Yeah, I just looked at Westlaw. I didn't see anything listed.
Okay. I guess we want to ask, any questions among the attendees that you want to ask each other? Based on the presentations and, kind of some of the discussion today, some of the points that you may want to highlight or bring up.
Well, I'll ask one to Bill and Charlie, because I was thinking about this from kind of as a practical matter. We were talking this morning about the idea that schools can now perhaps include a broader class of people under the ministerial role. Do you think that may have a bigger impact with K through 12 than with higher ed, in the sense that higher ed is so competitive these days in terms of you need people who are great scholars, and you want you want those people to attract students because it's all about kind of the marketing these days. And I was just thinking, as a practical matter, what will win out at religious schools, because there's only a niche in terms of attracting students for so many schools that are kind of highly restrictive. You want the best faculty, the top researchers, the top scholars. And, I think if your university, with some of the things that we were talking about, if your university prohibits interracial marriage or something like that, you're going to lose a ton of good prospective faculty and also probably a lot of students. So I just wondered if you saw universities tending to want to stretch that as far as it could go.
I don't do that much on the universities, and I'll defer to Bill on that, Lori. That's a really good question. I think that in the elementary, secondary schools, applying some kind of an explicit religious standard is probably more likely to be successful than in higher ed. If you think about it, the purpose, particularly elementary schools, is to inculcate the religious values of a tradition. That's their stated goal, whatever the faith tradition, Roman Catholic, Jewish, Islamic. By the way, happy Jewish New Year to our friends who are celebrating the high holidays right now. So I think maintaining a greater sense of what I'm going to call orthodoxy for the initial introduction to kids is going to be stronger at the lower levels. Let me make a distinction by analogy. I'm sure you're familiar with Levy Weissman that prohibits school-led prayer at public school graduations. The Sixth and Seventh Circuits allowed graduation at public colleges and universities, largely on the basis that the students are older and attendance is optional. And insofar as they're going to be educated, their minds are going to be open more. And if they couldn't deal with it, then they probably didn't learn too much in college. So I think there might be a larger impact in higher ed, but I hadn't thought about it. And I live in a different part of higher ed on the faculty side rather than on enrollment and recruiting and the like. I don't know if Bill wants to add on and say anything different, but does that make sense? Some sense?
Yeah, it's. I think it's. I think it's a good point. I think it's a great question. I think ultimately each institution has to decide for itself what its niche is and how it wants to go about achieving that. I think of some very strict small liberal arts schools, Wheaton, Calvin. I think of BYU, for example, Pepperdine, which have some pretty strict standards for all of their students and their faculty, yet manage to be significant institutions in terms of scholars and in teaching. If I think that there are people who want to be in that environment as a faculty member. I have talked to law professors at very strict law schools who have said, it's really neat for me to be able to practice my faith in the classroom, to be able to bring in religious influences on the law, to be able to pray before class, that sort of thing. But obviously, it's going to turn off a large number of people. And I think that's a choice that, each institution has to make for itself.
But I think, as you said, Bill, it's a choice. And one of the schools in our neighborhood, our area here is Cedarville, as you may know. And I say this with all due respect. I play hockey with a faculty member from Cedarville. Our former general counsel moved there as their general counsel. Nobody enters these schools or colleges without knowing what to expect.
Right.
Many people select it for that very reason. So I wonder, and again, I'm not challenging, I'm just thinking a little bit more.
Yeah.
I don't think it's going to change too much for those schools.
Well, I think what may change is they have the potential to define the ministerial exception quite broadly and probably to win. But you're not, as a student, you're not going to go to a Wheaton or a BYU or a Liberty unless you are willing to deal with the restrictions.
And I think another important item to keep in mind is the election. If Trump is reelected, the type of justice we'll see appointed will be very different than the type that President Biden would. And as I think we all recognize, it's at best a 5-4 majority, slightly conservative. Roberts many times can kind of go both ways, but there are likely to be some vacancies. I wish Justice Ginsburg the very best, but I think she's 88 and in ill health. Some of the others are pushing 80. I think how far and how long these precedents are respected is going to depend on whose 9 fannies are sitting in the front of that room.
And I think that's true. But I also think it's important to recognize that ultimately the support for constitutional rights depends upon a broad consensus in favor of constitutional rights. None of us is Amish. I don't know if there's anyone in the audience who is Amish, but our society has chosen, and the Free Exercise Clause makes this explicit, that the Amish can engage in behavior that is, somewhat different than the norm, and we accommodate that. And I hope that we can get to the point where we will allow people of faith to pursue their faith without interference from the government, while at the same time recognizing that the government needs to make sure that everybody in society feels welcome to fully participate.
As you know, I agree with you 100% in that. We've written that thing kind of that way together, but I really do think, without overstating it, we're at a real fork in the road, and I think it's going to take one direction or the other. I hope it's not going to be as dramatic as I sort of fear it does, and I hope we'll always respect that. But I think a large part is going to depend on who's sitting in the White House.
All right. We got a couple other questions now coming in. Somebody wants to know, are the requirements of FERPA an appropriate legal basis to deny information on a number of Title IX cases? I guess Dean Shaw or Mr. Throve, you'd be able to, you both could probably speak to that a little bit.
No, I don't think FERPA, because that's not information about a particular student. I think again, if somebody wanted to ask about what was happening in a particular case, FERPA would come into play. But I think certainly it's fair game to ask for the stats.
It's fair game to ask for the stats. There is some point at which giving the stats would allow someone to figure out the identity of the student. The easiest way to explain this is, if I want the grade distribution for Charlie's class that has 50 people in it, that's no big deal. If I want the grade distribution for an independent study that Charlie is supervising, then I'm going to know who got what, or what they got. The University of Kentucky uses a cutoff of 5. If the number is less than 5, we won't reveal it. Other places do 10, but if your numbers are large enough, then you're not going to be able to say FERPA for the aggregate data. There is an interesting Sixth Circuit wrinkle in that the Sixth Circuit has ruled that a governmental agency, and that would include a public university, cannot reveal the intimate details of a sexual assault except in the context of a criminal prosecution. So if Susie alleges Johnny sexually assaulted her, a public institution cannot reveal that information, even if it were permitted under FERPA.
All right, another question. Somebody wants to know, would a person who had been expelled for a sexual assault but wasn't convicted in a court of law have any standing to sue the school for defamation or loss of opportunity? And have there been any kind of cases like that?
Yeah, I mean, there have been some cases where exactly that has happened, with mixed success, because I think it's important that prosecutors and universities go back to what I talked about before, which is to say, the standards for rape in the state of Ohio don't exactly match the standards for non-consensual touching at the University of Dayton or at any other university. So, and this is again a problem that I think universities have, because we have seemingly become kind of a quasi-criminal justice system. It's helping people to understand that you know, in many cases, a person could be found responsible under this standard where consent is defined this way and not be found responsible on the criminal side. There was a case like that actually in Cincinnati, where I believe it was the Hamilton County prosecutor came out and said that, you know, oh, how could Xavier do this to this? I think it was one of the basketball players. How could they do this? And I mean, you know, and then there was litigation over all of that. But I think the litigation ultimately ended up being more over whether the process was what it should have been. But yeah, I mean, and that again is something I think it's just hard to help the public understand. You know, we have all kinds of rules on college campuses about behavior that you don't have in the rest of the world. So, you know, it's not the same standard.
Yeah, I mean, there have been a few. Recently, there was something at University of Wisconsin where they expelled somebody and but then later brought him back after he sued. There was a case with an NFL draftee at Michigan State, the case involving Xavier that Lori mentioned as well. But I mean, it goes to you know, the consequences of these allegations. You know, and again, certainly people who are guilty of this should be removed from the university community. But you know, it's very stigmatizing to say, you know, you're a rapist or you're a sex offender.
All right. I think we're getting close to wrapping up. Does anybody else have any final comments or anything from our panelists here that you wanted to mention, or thoughts that you wanted to share before we wrap things up?
I would just like to thank everybody for attending and participating. We hope you liked what we did this year. We'll be back next year. And I'm sure there'll be a steady supply of litigation to justify another panel next year. Dean Shaw and I will talk about this in a little while. She's just got so much going on with school reopening and that sort of thing. She's exceptionally busy. So I want to thank her for all the hard work she's put into it, and all the people behind the scenes that I mentioned earlier. We couldn't have done it without your help. So we thank you.
And I'd like to add my thanks to Charlie's, particularly for all those folks who've been working behind the scenes, for Leanne and Colleen and Paula and everybody who's worked so hard behind the scenes. And I want to thank our guests as well, our panelists as well, Charlie and Bill and Jillian. You know, and you made for a great event. And you know, I want to thank you, and I want to thank actually all of our participants for coming. This is a weird way to do this because we can't see you, and it is really
Right.
strange. Even when I'm teaching on Zoom, I can see everybody.
Yeah.
So it's a different experience, but we hope that by next year, as Charlie mentioned, we're going to do this again. We hope to be able to do it at Keller Hall. But I would also, I would also like to keep doing Zoom. Hopefully we won't need Zoom for COVID reasons by then, but it's been great to see some of our alum who I know are not in the Dayton area. So the one thing I ask of the participants too is, if you have an idea for topics you'd like to hear us talk about, either email me or email Charlie, because we love to hear about what you want to learn about. But again, thank you so much. And we will be in touch shortly about the CLE piece as well. So thanks. Have a good weekend, everybody.
And I can just add to that too, if you'll excuse me, Lori. If you're interested in perhaps becoming a participant in some way, we're certainly open to trying to come up with some different formats. Something I was thinking about this morning when I was talking with a mutual friend with Bill, and I think Jillian, at the Education Law Association, we used to have point-counterpoint sessions. So that might make for something new and different. My point is, we're open to other things. We're here to be of service as best we can. And so if you'd like to be involved in some way, we'd sure like to hear from you. And we'll keep in touch with you and let you know how planning is going.
And one last person to thank, Jordan, who has been amazing
Yes.
through all of this. He has
Oh,
been
thank you.
herding cats all day. So thank you, Jordan.
Well, thank you. You guys made it easy. So lots of great, interesting comments. So. All right. Well, I think that wraps everything up. We'll give everybody like an early 4-minute start, maybe on your weekend, or I'm sure like all of us, you have some stuff to do. It'll be working late into the night, but
Thanks again, everybody.
either way, thank you so much. And we hope to see you all next year.
Stay safe and well.
Jillian, it was so good to see you.
Likewise, Dean Shaw. It's good to see you too. Thank you for having me.
Just
By the way, your little
Thanks.
guy is adorable. I love it when you post Facebook pictures.
Thank you. He's getting so big. He's so delicious.